Starting a lordship from time to time.
Yes, today. Which one? Item number?
Number 98. Urgency is one with a very serious matter. I have a pond, ancestral pond, which is used for the clearing of fishes for our families, and there is a bathing ghat. People use the same. Now, some hooligans and other antisocial elements started construction over there. We wrote to the police inactive. We wrote to the Panchayat. Panchayat said, yes, it is unauthorized. I have got the document. I have taken the photograph. As such, my lord, I have come before your lordship. Unless your lordship intervene in the matter, my lord, we are helpless. Hooligans and goons, political goons are at large now. It is very much difficult. I am a medical practitioner of internal medicine in Calcutta. Item number 98.
90. Motion.
If your lordship fix a date subject to lordship and sanction any date, I will inform the other side
25
so that your lordship can hear the matter on contest.
Okay.
Want and some protection from your lordship.
How will you do? আগামী 7 দিন হবে না? কালকে নিয়ে নেবো। ফার্স্ট ডে করে দিই। ফার্স্ট চল দেখি কি হয়। ওকে ফার্স্ট ডে Thursday. Day after tomorrow. Give a notice.
The urgency is that the private respondent is there making construction without having permission from the panchayat. And I have.
We'll go one by one. Returnable motion is not now. Yes.
I have raised complaint before the local police station.
Yes, not now, sir.
Item number 263 of the monthly list.
It is monthly list. Yes.
It's number 907.
It is monthly. Supplementary.
I am praying for upgradation. Page number 907.
Not now. No update.
Permitted to mention this is for non-prosecution. Matter is running in the list, monthly list. I have indicated it. I have given notice to the other side. Your lordship kindly me not read.
Will be permitted to mention, my lord, for upgradation. Because since, my lord, January, my lord, the matter is going on in the list, my lord. It is not touched, and therefore, my lord, my lord, kindly.
See, item number?
My lord, urgency is this, my lord. My lord, item number 303.
No, not
303, my lord. My lord, 303, my lord, it is a very much urgent matter, my lord.
No, it's a non-prosecution. Non-prosecution. So, you mentioned target.
Kindly hear me for a moment, my lord. It is very hard. Because, my lord, encroaching 303, my lord. My lord, encroaching the, my lord, passage. My lord, the without any permissions of the panchayat, my lord, the private respondent is constructing his house. And my lord, panchayat has wrote a letter, my lord, without any taking permissions of the panchayat, he is, my lord, constructing. And my lord, we are facing very much trouble. My lord, the petitioner
everybody
did not take any action.
How can I upgrade? Every matter cannot be upgraded, sir. No. No upgrade is not. Yes.
My lord, January it is, my lord,
no.
In the list, my lord.
No.
Leave to file this writ application, my lord, urgently petitioner, my lord, is the Panchayat Pradhan of Uttar Kusum Gram Panchayat, my lord. Of the IATQC, of the, my lord, Congress, my lord. But now the problem is, my lord, petitioners, 11th B of the, my lord, the constitution meeting, some of the members, membership of the Panchayat have been cancelled. my lord, now the petitioner is facing, my lord, the BDO block development officer, my lord, with hand in gloves with some of the members. Even I am not entered my lord to discharging my duty, my lord. My lord, some action has been initiated by the block development officer in respect of his notice, and my lord, I am not even entered by my lord, the panchayat, my lord,
So what is the urgency?
the
File it.
urgency is, my lord, the panchayat pradhan not discharging his duty, my lord.
File it, let it come in the list.
My lord, may I, my lord, this,
Am I going out? Please wait.
May I
Yes.
permit to mention one matter for inclusion, my lord. Is urgency is my lord, cultivable land, whole huge humongous property has been constructed and still going on. Complaint has been lodged, FIR was lodged. Other
This is a
things
motion.
no, it is for inclusion, my lord. It is all. It was in the
Inclusion under
inclusion mentioning motion, my lord.
motion. Motion did.
My lord, same
Since July
Inclusion
2024,
by
the unauthorized construction is going on.
Oh, update isn't right now. Yes.
my nuisance for group file matter, the Panchayat Pradhan and the Panchayat.
Motion.
There has been a huge construction over and above my private passage by constructing a cantilever and the entirely blocks my passage. I cannot enter my own house. There were appropriate,
Is it appearing?
reading I am a
It is a motion or returnable motion?
Right.
No, returnable or motion only.
no, on motion. It's not
Motion.
returnable. It is coming up for the
Motion.
first time. I have.
Motion list করো। এই motion যেগুলো থাকে লিস্ট নিয়ে নাও।
My lord,
Under the heading motion law.
Lordship also the motion, lordship.
Not now. Not now. You have a yes.
The work order will be issued very soon, my lord. If the work order will be issued, then my petition will be infructuous, my lord. Item
Motion.
number 175 of today's list, my lord.
তো থাক ওখানে 2025 when did you file this when it was filed What?
My lord, 25. Of
when in 25 when did you file that and when the work order is about to be issued
my lord, the work
when was
order,
the NIT floated
my lord, I don't have the brief right now, so I
come tomorrow
my lord, item for, this matter was moved on of 14 January. There is direction 29 January. I have given the notice, my lord.
returnable
Yes, my lord.
the list করো
My lord, may I be permitted to mention this? It is appearing as item number 136 of today's list. My lord, I am staying in a premises which has been obtained, which the developer has obtained a sanction plan. It is unauthorized sanction plan obtained by fraud, my lord.
unauthorized
The sanction plan has been obtained by fraud, my lord. So any date may be fixed, my lord, to
no date we will go serial yes
129, my lord. Really, subdivision officer, my lord, passed a demolition order, my lord. Today is the last day, my lord. Any date fixed, my lord. 129, my lord. 120.
where is the notice
I have all the, but
where is the order of the demolition
I have annexed the order, my
you are not carrying it you are not carrying that come tomorrow
lordship, inclusion for restoration, lordship. Inclusion for restoration.
restoration কি দেখে নাও এটা ডেটটা দেখে ডেটটা
lord. Item 375 of the contempt application.
contempt arising out of which order
My lord, the order passed by the Honorable Justice Joyman Lovaksi 4 months ago, my lord. I have communicated three times. I have completed, but no.
how this court has determination if the order is passed by Justice Bakshi how can I take that in a contempt petition Huh?
Active contempt is actually.
new motion give
New motion.
lordship.
My lord,
Kindly allow me.
motion থাকলে না
my lord, may I be permitted to mention few applications for restoration? Enhancement of salary. Honorable Justice,
if you start like this then I will stop and call the list you are there I am also here Huh? One by one you will get your
My
opportunity
lord, may I be permitted to
yes Mr. Mahata
Cancellation order of already 2018 my lord sanction was granted. I have it as a constitution. Now my lord
Please come with the demolition order issued by them. Where is that? Kindly produce that at the time of mentioning tomorrow. Yes. No.
My lord, when Miller hearing, Miller was concluded, Miller for your lordship in November 2020, judgment, Miller reserved.
What is this?
Miller, read petition, Miller land matter.
My lord, may I be
After what
permitted
mention
to
of
mention two applications for restorations?
restoration application. Date 24. হবে কার application?
24.
আর রিট পিটিশনটা
23.
রিট পিটিশনের নাম্বার কত?
Two applications.
নিয়ে নাও।
বললাম তো সমান পাঠিয়ে দিতে বললাম
মোশন
One matter is because the selection procedure is under question and the selection is going to be held next week. And the court had produced.
দেখো রে লিস্টের মোশন বলছে দেখো লিস্ট ইট ইজ দেয়ার ইন দি লিস্ট লেখেন
Lordship, may I confirm one matter for upgradation?
নো অ্যাবসেন্ট নো
Lordship, the panchayat, your lordship.
Lordship, may I be permitted to mention this matter for inclusion in the list. This matter was being heard by Honorable Justice Kapoor, and as per his lordship's direction, this matter was to appear on 28th January.
রিটার্নেবল
Listed motion. The copy of the order to kindly.
আরে এতে পাঠিয়ে দে রিটার্নেবল মোশনে পাঠিয়ে fraud IFSC fraud involved delivery is not a penalty. Fix. কবে আসবে বলেছিল 28 জানুয়ারি রিটার্নেবল মোশনে দিয়ে দাও রিপোর্টের জন্য মোশন রিটার্নেবল মোশন
Lordship, I am praying for enactment of salary lordship, review of suppression, Honorable Rachis Aniruddha Rai, please to pass an order direction upon the BDO to consider my representation and file a report. And Honorable Justice Robi Kishan Kapoor, I am satisfied him that the report is scout casting. That's the reason
রিপোর্ট ইজ
scout casting in the street. That's the reason the Honorable Justice Robi Kishan Kapoor grant me liberty to file the exception. Lordship. Exception also ready, Lordship.
রেডি
Returnable motion, Lordship.
রিটার্নেবল মোশন লিস্ট
170 of monthly list, Lordship.
170
72
172 রিটার্নেবল মোশন কি করে হচ্ছে
monthly list, Lordship. Vishwanath Das.
দেখো রিটার্নেবল আছে
আমাদের তখন ছিল না কেন
ওই তো লিস্টে মান্থলি লিস্টে 172 বলছে ও সরি it will come 172 বিশ্বনাথ দাস yes ও এসে যাবে আমরা কতটা গেছি গো লাস্ট ডেতে রিটার্নেবল মোশন কতটা হয়েছে it will reach yes
One matter, my lord, it was taken up by Honorable Justice Kapoor, my lord, on 17th of January. and it was made returnable on 30th of January. I have served notice upon all the respondents and let the matter appear.
Returnable motion.
Lordship, may I have permitted one matter is for upgradation, your lordship, is item number 342 of the
No
combined
upgradation, right.
monthly list, your lordship.
I have a lordship's leave to mention item number 198 of the days list. This is returnable motion. My lord had fixed the matter on 14th of February 2025.
Huh.
My lord, the problem is, my lord, the panchayat authorities has refused to, my lord, renew my trade license. Now, my lord, trade license is told, my lord, I cannot run my business. My lord, this is a question of livelihood. Lordship had
Wait.
directed the state authorities to file a report.
When? By?
On 6th February, your lordship had passed this order. Returnable was on 14th February.
Okay.
Report
They have filed.
that I have been served. I have filed a exception to the report. And lordship had also directed me to serve upon the private respondent and file affidavit of service. That was also done.
Number কত?
আজকের 198 supplementary listed.
হুম। 14th এর আগে নয়। Not before 14th, huh? No upgradation right now. You are added respondent?
No, petition.
Mention
My lord has
afterwards. Yes.
Directed me to serve
Not.
fresh notice served. Affidavit of service is also ready.
Right now, no upgradation rate.
Article 375 of the monthly list, my lord. This is my, with you notice I was mentioned man, for upgradation. We have complete my work in the panchayat. Till today, no completion certificate has already been done, but no payment has yet been about 3 years.
Afterwards. Yes,
My lord.
afterwards, not upgradation right now.
Item number 342 of the monthly list, your lordship, it's had by Mr. Justice Kapoor, your lordship.
Yeah.
I am for the petitioner. The panchayat is encroaching my land and build a illegal construction, your lordship.
Huh.
It's returnable. The data is
Let it be there.
My lord, may
I permit, my lord, one matter, my lord, to be mentioned, my lord. It will come up in the list to be mentioned.
Why?
My lord, order has been passed by his lordship, the Honorable Justice Kaushik Chanda. My lord, before puja vacation. My lord, I have annexed the order. My lord, direction to the state authorities to produce all relevant records within 2 weeks after puja vacation. And after 3 weeks, my lord, the matter will come up in the list as to be mentioned. My lord, I am for this, my lord.
So the order, where is the order?
My lord, I have order. I have annexed, my lord. Kindly see.
It is not in the list, right? Video issue notice. The list called returnable motion. To be mentioned it নিয়ে এসো, so returnable motion should be there.
My lord, may I permit to mention as regard item number 80 of today's list, my lord. My lord, the petitioners are the owners of the Patta land, my lord. The private respondents are constructing their Awas Yojana building on their land, my lord. The petitioners are cultivating the same, my lord, since long, my lord. But now, my lord, the private respondents are restrained them to cultivating the same and they are constructing their Bengal Yojana Awas, my lord, on their land, my lord. My lord, the petitioner, my lord, made several representatives before all the concerned authority, but my lord, till date nothing has been done.
Serially will go. Yes.
My lord, may I permitted to mention, my lord, for upgradation monthly list item number 450.
Yes. No upgradation.
May I permit to mention, my lord, last Thursday I mentioned before lordship, but due to lack of service, my lord was directed me to come with a fresh service. Is the returnable motion It's in the month list, the item number is 347 and 286, my lord. What has happened, my lord? This matter, the respondent is constructing the a building over the water body. And Justice Kapoor has taken up the matter where Justice Kapoor has directed to file a report by the panchayat, but they are not filed a report yet now. And the matter was supposed to come on 27th of November 2024, but it has not come into the list, my lord.
27th November.
27th November. And they are still now they are filling up the water body.
The report has been filed.
Had already served
347 and
286, my lord.
both are same.
Both are same.
Notice you have given to the
My
state.
lord.
$286.
Dilip Mondol and others. 347 is Osiman Bibi and others.
Both the matters state advocate is same.
Had already
No need. 286 and 347 should be mentioned in here. Any copy of the report not served?
no, madam, no report has been served.
286 and 347 a monthly list to be mentioned.
Kindly to mention item 459 of the combined monthly list. Initially, I have mentioned before your lordship, it's a returnable motion, my lord. By an order dated 16th January 2025, the Honorable Justice Kapoor was pleased to direct the matter to appear on 6th February. I have mentioned on that day, your lordship was pleased to direct the matter to appear, but from it is appearing as 459. And what happened, my lord? And I have constructed a boundary wall taking permission from the panchayat. Now the stand has been taken by the panchayat that there is no such permission, since no record is available. Accordingly, there is an order directing the state to file a report. No report has yet been filed till today. I have not yet been served a copy of the report.
Last order.
Last order, I have handicapped. I can show from my mobile.
449.
459. Vishwajit Pramanik, my lord. Specific direction to file a report and take an instruction with regard to my permission.
The construction has been stopped.
No, I have constructed now. They are taking steps to demolish that construction boundary.
It is to be mentioned in ESO 459. You report that.
45.
You given a notice to the London
I
advocate.
have given notice. I will intimate the Mr. Mondol is appearing. I will intimate. 45.
Your lordship.
590 to be mentioned in ESO.
Your lordship may kindly permit me to mention one matter. It is item number 360 of the monthly list, my lord. My lord, this unauthorized construction is going on by the private respondents. They have taken the permission from the respondent authorities by using their influence. It is made completely illegally and unauthorizedly, my lord. I have given the complaint to the respondent authorities, but no steps has been taken, my lord. It can,
Afterwards, not now.
my lord, kindly, my lord.
No.
Lordship, may I be permitted to mention item number 89? Lordship, Sabhadipati has died more than Sabhadipati of Panchayat Samiti has died more than 6 months back. We have made a representation. There is a specific rules of Constitution Rule 6 that within 1 month election should be done. It has not been done yet. Lordship, item number 89. Kindly upgrade this matter and hear it out. Lordship, any day, Lordship. Today's list, Lordship. Item number 89. Lordship, there is a specific rule that within 1 month the election should be done. They have given charge.
Rule to the Panchayat Act. Which rule?
Panchayat Constitution Rule.
When did he die?
Lordship, more than 6 months. In the Lordship rules.
Who is this? Applicant is the?
Lordship, applicant is the opposition leader and other members.
Oh, yeah.
Panchayat Constitution Rules, Lordship.
Which rule? Which rule, sir?
Lordship,
Which rule?
Rule 6, Constitution rules. সভাধিপতি regarding সভাপতি of পঞ্চায়েত সমিতি।
Copy of the petition?
Lordship, it has in fact I don't have now, but it is in the
Mention
list,
tomorrow with the petition and annexures.
petition and annexes.
Yeah.
Item number 1,
One.
For respondent numbers. 8 to 14.
This for the petitioner.
Matri Kumar Mahato.
Okay. Oh, group B. So Banerjee, what is this matter is about?
But this has been released by Justice Tirthankar Ghosh, but it has been assigned to your lordship, my lord. It is a matter in which in a panchayat, my lord, but they are complaining of certain irregularities regarding plots and constructions thereof. But the main writ petition is regarding police inaction. But there is an order passed by Justice Subroto Talukdar, but that is page. I'm extremely sorry, but I'm not.
Yes, yes. Just
But
give me
kindly
the
comes to page number 29, my lord.
29.
Which is also bolte boleche. But this was the earlier order passed, is an identical writ petition. Relevant portion is at page 35.
Okay, the allegation was of unauthorized construction. Okay.
Lord, over my plot, my lord, private respondent, my lord, constructed house on the scheme of Pradhan Mantri Awas Yojana. But the record says I have the purchase deed, I have the record of right in my name. I approached before the Panchayat Authority, my lord. Panchayat Authority since did not take steps, my lord. I approached before this Honorable Court. Honorable Court directed the Panchayat Pradhan of the concerned Panchayat to consider my representation. That has not been considered. Thereafter, my lord, I approached before the police authority also. On the, my lord, inaction of the police authority, my lord, I filed this petition, my lord. This petition was taken up for hearing by the Honorable Justice Tirthankar Ghosh, my lord. When his lordship has been observed that it's the determination of the panchayat, so matter has been released and assigned before your lordship.
Achha.
But till date, my lord, Pradhan has not taken any steps, my lord, on the basis of the earlier order, my lord, dated 19th November 2018. I have served, my lord, to the private respondents as well as all the respondents.
What is this complaint of 28 February 2024? This was before the Pradhan or the police officer?
28th February, my lord, before the officer in charge. Lord, may I pray one thing, my lord? I file detailed representation before the Pradhan, that will be considered within a
How?
That's the purpose of sub. Otherwise, my
The scope of the writ petition cannot be changed.
I shall file
So-
face representation, my lord, as per my lord's.
How can I give you liberty? You say that there was inaction by the officer in charge. The court says that it is falling under the Gram Panchayat. The representation may be with the officer in charge of inaction.
Here, my lord. That order not been complied with, my lord. So I have not filed contempt application. My purpose will be served, my lord, if I file this representation before the Pradhan.
What is your submission?
But first thing is, but after passing of the order by Justice Subroto Talukdar, the order was never communicated to anybody. But what has happened after this order being passed, it is not there in the writ petition. On the contrary, there has been encroachment. But for encroachment, a writ petition cannot be filed. There is a specific statement in the writ petition, there has been encroachment. Apart from showing your lordship that they do not have any right over the properties, I mean the plot numbers that have been mentioned, there is no document regarding the same in the entire writ petition also. But how could the police be responsible for all this, Mulad? Mulad, the representation that has been given, please.
Record of right in my.
Wait.
The last representation that has been given in 2024 is not to the Panchayat but to the police officers. Officer in charge, Shampur Police Station. Order was passed by Justice Talukdar, but upon respondent number 6 shall grant an opportunity of hearing. At page number 35. What is the fate of that? They have not disclosed.
Okay.
And
So
Millard, if
you did not take steps in accordance with that order passed by this court?
that is the main thing, Millard. And Millard, there
I have been told, my lord, that order has been communicated, but.
Where is that? Did you communicate? What is the document that you have communicated this order to the? But if there is an order which you have not complied, not communicated, then you come up to the court that there is illegality.
Communication, my lord.
Respondent number 6 should have been communicated to act in accordance with that order. Why this writ petition? There was no occasion to file another writ petition since there was an order by the court that you for consideration of your representation by the Pradhan. Again, you file an application without communicating the order. Who is for the state?
That has not been annexed, my lord.
I do not know they have been served or not.
State has been served.
Yes. Yes, Bill.
Two more things, if your lordship may kindly desire, Millard, I can place before your lordship, Millard. But in paragraph 3 of the writ petition, no, 8 থেকে 12, private respondents. In paragraph 3,
If Pradhan is directed to consider my
Why? First, you have to satisfy whether you have communicated the order. If you do not comply the order of this court, why the affrays liberty should be given to you?
but paragraph 3 shows certain plot numbers. These do not belong to the petitioner. Number 1. But paragraph 9 of the writ petition says that there has been encroachment on the part of the private respondents. But if it is a case of encroachment, then a civil suit lies. It's a civil dispute.
Yes.
This is a writ petition just for the sake of filing a writ petition.
Given.
डेट देखिए प्रधान के बीच ডেট দেখুন কবে 17 সাল কি করে হবে? 18 সালে উইথড্র করে নেন, ফ্রেশ করে ফাইল। Yes, suggest something, my lord. I am using this repetition, my lord, with liberty to approach the people.
That liberty cannot be given. You have to satisfy that you have complied the previous order of this court, that you have approached, communicated the order.
At present, could not find that.
Then this writ petition will be dismissed, since you cannot satisfy that you have complied the order of the court. You cannot agitate the same points each and every time. Or else I give you liberty to withdraw this writ petition. That is all. Mr. So and so, learned advocate for the petitioner, seeks to withdraw this writ petition. Mr. Shourodipto Banerjee, learned advocate, appearing for respond numbers
8 to 14.
8 to 14.
Lordship.
8 to 14 leaves the matter to the discretion of the court. Or upper the affidavit of service filed on behalf of the petitioner is taken on record. Mr. Mahata. Mr. Mahata is there. You appear in this case. Mr. Lolit Mohan Mahata, learned additional government pleader, is requested to appear in this matter since the state is unrepresented. The concerned authority is ready to regularize the representation of the petitioner. On the submission of the learned advocate for the petitioner, the writ petition being WPS 6842 of 2024 is dismissed as withdrawn. All connected applications have been disposed of interim order.
আবার definition দিন যে ফাইল করতে হবে। নতুন করে definition দিয়ে
Item number 2,
for the petitioner, Milord. Milord, respondent number 7 has constructed illegal building on the scheduled plot.
What is
And
this
all-
application? This is an application for restoration.
Yes, Milord. Service of.
B is 3.
Milord, the private respondent number 7 has constructed illegal.
Mr. Johor Dottu is engaging at court number 20. He is appearing item number 2. He informed me allow the restoration.
Hello. Now, is there any delay in filing the application?
Was called on 24th May 2024, Milord. 22nd May 2020.
What is the time period to file the?
Petitioner is senior citizen, Milord, and was suffered that time in fever. This is why he submitted later, Milord.
Related Limitation Act alone. Can 1 of 2024. Opposite affidavit of service filed on behalf of the petitioner is taken on record. Can 1 of 2024. This is an application for restoration upon recalling order dated 22nd May 2024. By order dated 22nd May 2024, the writ petition was dismissed for default. Mr. So-and-so, learned advocate appearing for the petitioner, submits that. Which paragraph?
That paragraph number 5 minute.
Submits that. Due to the learned submits that the learned advocate for the petitioner overlooked the cause title and failed to appear when the matter was called on, resulting in dismissal of the writ petition. He seeks for the restoration of the writ petition upon recalling the order of dismissal. Mr. So-and-so, learned advocate appearing for the state respondents, leaves the matter to the discretion of the court upon going through the amendments made in the application and these submissions advanced on behalf of the petitioner. It is found that sufficient cause has been shown. Accordingly, the order dated 22nd May 2024 is recalled. The writ petition being number WPA 12063 of 2023 is restored to its original file and number. Can 1 of 2025, sorry, 2024, 2024 stands disposed of. What is this writ petition?
Pilot, private respondent number 7 has already constructed illegal building on the schedule plot number 530 and learned block development authority BDO has already taken step annexer P3 Milot, but the Pradhan of the concerned Gram Panchayat is not taking any action. Repeatedly representation has been submitted by the petitioner annexer P4, annexer P5, but he is silent, and there is a nexus Milot that petitioner is continuously suffering due to this illegal construction of the respondent. Due to the silence of the respondent authority, he has also constructed another Smithy shop on the schedule plot that is in question also Milot. So all these constructions should be demolished. It is the prayer of the petitioner Milot, humble prayer Milot.
And let them consider the representation. Which is your representation?
Milot, last representation 22nd March 2023 annexer P5 Milot, and video instruction Milot page number 21 annexer P3. And Milot, petitioner is seeking relief under the West Bengal Panchayat Amendment Act 2017 of the subsection 5 Milot, annexed at the last page of the petition Milot. That where in any new structure of new building or any addition in the structure of building is being or has been erected or made, as the case may be, in contravention of the provision of the subsection 1, and permission granted, authority shall refer the matter to the subdivisional officer.
This amendment to which section?
Section 3 Milot.
পঞ্চায়েত এটা পঞ্চায়েত বইটা কি? Amendment Act 2017 আছে? Amendment Act 2017? You are carrying the book 2017 Amendment Act?
No, Mr.
Who will consider this representation? Respondent number 5.
Milord, by provision, respondent number 5, but as there is an excess and video is also repeatedly failing, so kindly allow respondent number 3. গ্রাম পঞ্চায়েত না 5 নম্বর প্রধান তালগাছড়ি 1 গ্রাম পঞ্চায়েত না যেহেতু
Rule response number 5. Asha.
Address people wrongs.
Huh?
The Anshul Pradhan. There is no such of.
In place of Anchal Pradhan, it will be only Pradhan. But in the annexer P3, video already clearly mentioned it to the Pradhan Talgachari 1 GP. Yes.
Which is the petition of which it has been referred in videos later?
Milord, annexer P4. না P3 যে ভিডিওর যে লেটারটা তার annexer কোনটা ছিল
Okay. This petition has been filed. Seeking direction upon the respondent number 5, Pradhan Talgachari 1, Gram Panchayat, for consideration of the representation dated 22nd March 2023. Alleging of illegal unauthorized construction over Dag number 530. 530 belongs to whom?
Belongs to Milord, the petitioner.
Kotian number 1023 Mouja Talgachari, jail number 108 PS Ramnagar, Purbo Medinipur, measuring more or less 2 shatoks of land. Mr. So-and-so learned advocate, appearing for the petitioner, submits that the private respondent has undertaken unauthorized construction over the land belonging to the petitioner.
And also
On
occupying common road, Milord.
the petitioner in the year 2017 made representation before the local Gram Panchayat as well as to the block development officer Ramnagar 1, Purbo Medinipur. Stop. The block development officer directed the Pradhan Talgachari 1 Gram Panchayat to resolve the problem and send a report to the office of the block development officer. However, no steps has been taken by the respondent number 5. Once again, on 22nd March 2023, representations were made before the concerned authority, including respondent number 5, Pradhan. The address is also wrong. You make Anchal Pradhan, then Jalgacharia.
Talgachari, Milord. Sorry, it will be Talgacha.
He indicates that the representation, sorry, in the representation, the designation has been mentioned as Anchol Pradhan instead of Pradhan. He seeks that the respondent number 5 be directed to consider the representation of the petitioner dated 22nd March 2023 in accordance with law. Mr. So-and-so learned advocate appearing for the state respondents also submits that the matter be relegated to the local Gram Panchayat, respond number 5, to consider and dispose of the representation of the petitioner.
This is 23. It is 25.
No, no, no.
So liberty is granted to him to file a comprehensive.
It may consider. It may consider.
That will solve the problem.
Considering the above submissions, petitioner is granted liberty to file a comprehensive representation before the respondent number 5 within a period of 2 weeks.
15 days.
2 weeks, within a period of 2 weeks from date whereupon the respondent number 5, Pradhan Talgachari 1 Gram Panchayat, shall consider and dispose of.
Myself, as there is video direction, so this honorable court can pass the direction upon.
No, upon the Pradhan, you file a comprehensive representation. You know, who upon such representation been made shall adopt the following procedure. Cause inspection of the property in question upon notice to the petitioner as well as to the private respondent. Prepare a rough sketch map. Prepare a report along with a rough sketch map. The parties, including the petitioner and the private respondent, shall be heard thereafter upon notice. Next, upon hearing and pass a reasoned order. Shall pass a reasoned order upon hearing and the inspection. If it occasion, the respondent number 5 shall take the proceedings to its logical conclusion and act in accordance with Section 23 of the West Bengal Panchayat Act. With the aforesaid direction, the petition is disposed of. The aforesaid exercise shall be done within a period of 2 months from date of communication of this order. Submission of the representation. Take correct. Representation with the opposition is disposed of. Petitioner is directed to communicate this order to respond number 5. Gram Panchayat. Yeah.
Grateful, my lord.
ওটা দাও। হ্যাঁ দিয়ে দিন ওটা দিয়ে দিন
Item number 3. I am for the petitioner, my lord. I have heard 2 times, my lord. My private respondent has received. Unauthorized construction, my lord. 1414, my lord. And set P3, my lord.
Page number
14, my lord. Annexure P3.
জমির সম্পত্তির কিছু অংশের মালিক This is a joint property?
Yes, sir, joint property. My lord, please on the record of right. 94, my lord.
Nine, 3.
94, my lord. It's 16, my lord. Photograph of one of the structures. 16. And it's a P3 one.
State
And private is still had
served.
Yes, madam. Private is received. I can tell you what, madam, condition.
Video. Insufficient. 80. On hold. Name 3 district Panchayat on hold. Local holiday. চলো see. Wait. No, individual sir, ঠিক আছে। Cricket খেলা শিখে যা। Who will appear for the state? You appear, there is nobody for the state. Give a copy.
না এগুলো এই জিনিস না
দুইটা ব্যাপার প্রাইভেট রিসিভ করেছে প্রধান এটা ট্রাক রিপোর্ট করি এটা আমি সাজেস্ট করি চেষ্টা কোথায় রিসিভ প্রধানকে দেওয়া হচ্ছে তার রিসিভ My lord, whether the Pradhan has duly been served this representation, and this representation, one line is there, অবৈধ নির্মাণ, without any having sanction plan or not, he has not described it, অবৈধ নির্মাণ, it covers everything. But, my lord, I do not find that whether this representation has been served to the Pradhan.
Page 18.
Page 18 is, my lord, my lord, it is sent, my lord. That report is
Not
not
let
there.
him file this before the Pradhan. If he has not received it, he will act in accordance with.
Well,
He
if
represented.
it is received, then he will inquire into and he will take a
Direction be given to him to annex this representation along with the order, copy of the order.
My lord, and my lord, if it is found that there is illegal construction, as per section 23, subsection 5, he will refer the matter to the subdivisional officer for further course of action.
This writ petition has been filed for consideration of representation dated 25th March 2024, alleging of illegal construction on a portion of land lying and situated at LR Dag number 293 and 294 respectively, jail number 125 in Mouja Bali Daho, within the Keradin, comma, police station, Honia Khali, district Hooghly. Where it is the contention of the petitioner that the private respondent, affidavit of service private respondent number 9 is making illegal unauthorized construction over the Pakka construction over the aforesaid property in question. On 25th March 2024, a representation was made before the concerned local Gram Panchayat with Pradhan Kolo. Respondent number 7. Pradhan, local Gram Panchayat, respondent number 7. However, no steps has been taken. None appears on behalf of the state respondents. Mr. Lulit Mohan Mahato, learned additional government pleader, is requested to appear in this matter. Let the appointment of Mr. Mahata on behalf of the state be regularized by the concerned authority. Mr. Swenso, learned advocate, appearing for the petitioner, submits that the direction be issued upon respondent number 7 to consider the representation of the petitioner. Mr. Mahata, learned additional government pleader, also submits that the matter be relegated for consideration by respondent number 7. Considering submissions above, the respondent number 7, Pradhan Gram Panchayat, Gudab Gram Panchayat, is directed to consider and dispose of the representation of the petitioner dated 25th March 2024 by adopting the following procedure. মন্ডল বাবুর কাছে দেওয়া আছে মন্ডল বাবুকে আগে একটা ডিকটেশন দিয়েছি ওতে প্রসিজার বলে দেন তবে হবে within a period of such exercise shall be completed within a period of 2 months from date of
if it is found that there is illegal construction, the matter will be referred under section 5 of section
he will
23
act in accordance with section 23 of the West Bengal Panchayat Act.
Subsection 5 of section 23 of the West Bengal Panchayat Act.
The 23(5) of the West Bengal Panchayat Act. With the aforesaid direction, the writ petition stands disposed of.
The copy of the representation be served
Copy of the
along with the order.
copy of the representation along with copy of the order be served upon respondent number 7, Pradhan Gulab Gram Panchayat.
Deeply obliged, my lord.
ঘরে যেতে পারলাম কালকে হবে ডাকো রিটার্নেবল মোশন বারোটা বলেছি না 12টা থেকে নুন অনওয়ার্ডস হ্যাঁ কত নম্বর আইটেম
Item number 179. I'm appearing for the petitioner.
Last occasion.
Your Lordship was pleased to direct the concerned BDO to make an inspection. But no, in spite of your Lordship's order, no inspection was made.
There is no direction, just directed by Justice Shampa Sarkar on the basis of the same. That inspection was done. I have submitted the report. Your Lordship's query was whether he has made the inquiry physically or he has made the inquiry on the basis of the available record.
Officer prior to filing of the inquiry report. Yes.
Now my instruction, what appears from the Malad instruction, he has made the inquiry Malad physical. On the on the date.
Thank you.
Was the 1/6/2020. Clarification. Joseph to setting down.
Yes.
My lord, report filed by the concerned BDO is totally relying upon the false statement of facts. Already, on the last occasion, your Lordship was pleased to indicate my learned friend to give instruction upon the BDO for inspection to the spot. Especially, my lord, paragraph number 13D. Milan masonry parts may read out, my lord.
Wait, sir.
Report of their report.
13D.
13D. Your Lordship was pleased to indicate, especially 13D, in the last order. Milan Missionary Parts states for a letter in his writ petition P4 where he seeks permission for laborers and mechanics to work for the said work of serial number 6 from BDO nullity 1. Next line. Any permission letter has not been issued from BDO nullity 1. And on the last occasion, my lord, the original receipt copy was handed over to Lordship and I was allowed to perform my work, my lord, to execute my work.
So your grievance is with regard to serial number 6.
Serial number 6. And thing is, my lord, this report only has come out with some photocopy without any affidavit. If somebody files any document, any statement without any affidavit, even, my lord, if I say this document is a manufactured, I can say, but it should come out before the court of law. When we are before the writ court, everything come with the affidavit, my lord. Without affidavit, if someone
What was the direction given for filing report? Only report
Only
or
report.
only
No
report?
direction for affidavit.
But my lord,
Mr. Sarkar was pleased to direct to make an inquiry and
My instruction is very much clear. I have installed, firstly, I purchased the motor, the solar motor, solar pump. I have purchased the pipe. I have fitted there for drinking water. It is not a fact that I have constructed one building, I have constructed one road, measurement to be taken, whether I have executed the work or not. There are so many questions. But anybody can, malab, at the first instant, anybody can see that pump is there, solar power is there, and water is coming from the
But a work order is issued and the work executed.
Executed, my lord.
Certificate of completion not issued in your favor.
My lord, the last occasion, my lord, I had demonstrated before your lordship that then time, COVID, full-fledged COVID was going on. That's why
After the COVID was complete, any other certificate issued in your favor that you have completed the work?
My lord,
Because until and unless the completion certificate is issued, you cannot raise bill with regard to your work.
grateful, my lord.
My lord, I will come to my writ petition number 20, page number 24, 22 onwards. Your lordship takes trouble. P1, that is P1. NIT. Notice inviting e-tender.
Page number?
Page number 22 of my writ application. There were total 9 works. 1, 2, 3, 4, 5, 6, 7, and 9. Accordingly, I have executed 1 to 5, 1 to 6, and 9. 1 to 5 and 9.
6 and 9.
6. 1 to 6 and 9.
Yes.
In respect of serial number 7, 8, not executed. But
not executed, work order was issued to you.
What was issued?
Okay.
My lord,
this has not been executed.
I was entitled to get the money in respect of 1 to 6 and 9. 1 to 5 and 9. 1 to 6 and 9. But all payments made. 7 except this 6.
9 also made.
Yes, yes. I already, my lord, I have annexed and I made my averment in paragraph number 14. 14. 14.
But these work which you have completed, that was also during the COVID period.
Yes. My lord.
In that work, in respect of that work, completion certificate was issued.
No completion certificate was issued in respect of other serials also.
Not issued.
Not issued. Never.
I do not know whether any completion certificate has been issued or not.
But it is a fact that bills have been cleared.
Bills have been
cleared. But 9 is concerned because, my lord, your lordship kindly see that in the inquiry report, it has been specifically held that serial number 6, 7, and 8 was not started. So for the 9 is concerned, it has been started. That's why, and he has completed. That's why it has been paid. My lord, BDO is the fact-finding authority. He has come into the conclusion. So far, the serial number 9 is concerned. That has been done. So far, the 6 is concerned. All are disputed question of facts, my lord, so far.
Your lordship takes trouble to go through the paragraph 5 of my writ petition, my lord. It will be revealed that payment in respect of 1 to 5 and 9 clear. Only 6 is unpaid. Serial number 6.
There is a dispute. That's why it has not been cleared.
Without any certificate. This is admitted claim, my lord.
Why admitted? They are not admitted. Then it cannot be said that it is an admitted claim.
If I pay a bill.
or my lord, another submission, my lord, your lordship may refer the matter before the SDO. Both the parties will appear before him and sort out the dispute. Because here SDO is also.
And even your lordship can appoint one special officer from this court also.
Yes.
SDO, okay, BDO is the authority which has.
BDO is the fact-finding authority here. Therefore, SDO is the superior official.
Instead of SDO, my lord, I'll be suggesting the district magistrate. That would be better, my lord.
Yes, he is also the necessary part. Respondent number 2.
54 onwards. সবগুলো আছে my lord,
Yes.
Kindly have a look, page number 54 of my read petition, 54 to 64 না কত 54 to 62 64 also completed successfully. Office of the Pradhan, Paikpara Gram Panchayat.
But this is in respect of the other work.
Other.
So did he file any application before the district magistrate?
No, he did not file any application.
এটা
He has filed the application before the Pradhan
এটা কোন serial?
and Panchayat and Nirman Shayat. Not before that. At page 69.
District magistrate is a party in the writ petition.
Respondent number 2.
আসুন তো। His writ petition has been filed seeking direction upon the respondent authorities and or their agents and or assigns and or offices and or subordinates to issue payment for payment of 6 lakhs
6 lakhs.
Payment of rupees 6 lakhs for installation of solar pump, including supply and fitting and fixing of pipeline of water at proper position at various place of village Mohalla within bracket near Ismail House under Nolhati Development Block. Location Mouja Sujalpur, jail number 63, plot number 446. The petitioner is a contractor and proprietor of a company under the name and style of Milon Machinery Parts, italics, having registration number 1981563440. and carries on the business of works contract. Full stop. The petitioner participated in notice inviting e-tender being tender number WB BHM WB slash BHM slash NAL dash 1 slash PGP slash NIT dash 01 slash 2019-20. The petitioner was the successful bidder and was issued work orders for execution of work under serial number. No. Which are the total work orders? 1 to 6 and 9.
1 to 6 and 9.
These were allotted to you.
Yes.
1 to 6.
All were allotted to me.
1 to 9.
1 to 9.
1 to 9. The petitioner contends that he has executed works in respect of serial number 1 to 6 and 9. So the payments in respect of serial number 1 to 5 and 9 has been made. However, even upon completion of the work under serial number 6, the payment of rupees 6 lakhs in respect of such work has been withheld. The petitioner made representation before the petitioner has made representation.
Yes, my lord.
Before the Pradhan, respond number,
Video
and Gram Panchayat, no?
Yes.
Pradhan Gram Panchayat, Nirman Soya, video. Copy to district magistrate, SDO,
Pradhan
everyone.
and BDO. Pradhan down, respond number কত এটা?
Pradhan is respondent number
Pradhan
8. 8.
দাঁড়াও, প্রধান পুরোটা দিই। প্রধান পাইকপাড়া গ্রাম পঞ্চায়েত, respond number 8.
Page 69. Respondent
As well as to block development officer Nolhati 1 for ওটা 4 block development 4 for redressal of his grievance in payment of the outstanding dues of rupees 6 lakhs pertaining to the work completed in respect of serial number 6 of the notice inviting e-tender. Since no steps has been taken for payment of the outstanding dues, hence this writ petition. Para. Upon filing of the in compliance to the order of this court, the report of the block development officer Nolhati 1 development block, Nolhati Birbhum, is placed on record.
I also filed exception to the report.
Exception to such report has also been filed. May para. Mr. So and so learned advocate appearing for the petitioner submits that although in the inquiry report it is stated that no permission was granted to carry out the work under serial number 6. However, this letter has been annexed to the writ petition.
Yes.
However,
P4, page 38.
however, as per the endorsement,
Page 66. Sorry, madam.
endorsement of the block development officer Nolhati 1 development block on letter dated 1st April 2020 at page 66 annexure P4, the petitioner was allowed to carry out the work. Hence, such contention in the inquiry report does not is short of merit. He further submits that the installation has been completed. Stop. And accordingly, continue. And accordingly, the petitioner is entitled to the outstanding dues. On the contrary, Mr. So-and-so learned advocate representing the state respondent submits that the block development officer has categorically stated that the work in respect of serial number 6 has remained is incomplete. At this stage, both the parties consent for relegating the matter to the district magistrate for resolution of the dispute. In view of such submissions, will you place a comprehensive representation before the district magistrate, or
My lord, all the representation made before the DM also.
you can cite the date so that he can consider that representation?
Yes, 15/6/2022, copy of
22.
page
number?
Page 69.
Page 69, madam, lordship will find from page number 73. DM is due and video.
No, track report.
Considering such submissions, the respondent number 2, district magistrate, Birbhum,
Whether the DM has received it or not, or the track report.
they will place. Oh no, this is an advocate's letter. In your own capacity, no letter has been, representation has been. Then I give you liberty to file a comprehensive representation before the district magistrate.
Mal.
Huh? You will
Adducing further evidences.
or produce all documents before him. As a submission, liberty is granted to the petitioner to submit a fresh representation before the district magistrate, Birbhum, respondent number 2, who upon such submission shall consider and dispose of the representation of the petitioner within a period of 6 weeks from such submissions, upon affording opportunity of hearing to all interested parties, including the petitioner, and allow the petitioner to produce all necessary documents.
Also, from the side of the video. All interested.
The petitioner as well as the block development officer to produce relevant documents. That also he can call for from the office itself, so not necessary. With the aforesaid observation, the writ petition is disposed of. Petition is directed to communicate this order to the district magistrate, respondent number 2.
I've only two submission. One,
But
the
may
court
I
has
get
not-
back that original one?
or that the court has not gone into the merits of the case. And second, yes, sir.
Merit.
And second thing, my lord, as we have not used any
It is,
affidavit,
it is made clear that the court has not gone into the merits since no affidavits has been called for. The allegations made in the writ petition is deemed to be not admitted with the aforesaid observation writ petitions. আচ্ছা এই রিপোর্টটাকে একটু টেকেন অন রেকর্ড করে দেবেন। Yes.
Item number 180.
None appears on behalf of the petitioner. It is found that on the last day, that is 10th February 2025, the petitioner was not represented. State is represented. In view of the above, the writ petition being number such and such is dismissed for default. All connected applications disposed of, interim order being vacated. Urgent photostat certified copy of this.
Item number 181.
This is my application. Earlier occasion, my lord.
Lord, I am appearing on behalf of the state.
11 November.
On behalf of the state,
My
Lord.
lord directed to file an affidavit. They directed them to file an affidavit.
Report.
Yes, my lord.
My
My
lord,
lord,
file
they
a
have
report,
completely changed their stand. My lord, kindly see the order dated 11 November
Lord, kindly-
2024.
Kindly the
They accepted
report,
that they will take
Lordship.
steps.
Kindly-
Now they have
kindly
came
see.
with a
What
my lord,
steps
plea
have
that-
been taken, Lordship? Kindly see the report, Lordship.
but they have not handed over a copy, my lord.
11? Which one?
11 November, my lord. Kindly see, my lord.
Whether
Order.
the state
It is
respondent
their acceptance.
because the violation of taking necessary steps appropriate
And it
order.
is the direction given by this honorable court. They are in a contempt, my lord.
Significant
They are directed to take steps, remedial measures to clean up the pond, my lord. And now, my lord, see the report.
Lord, he was trying and again and again, Lordship, and last step they have taken steps.
Yes.
My Lord, my Lord, Panchayat had trying several steps, my Lord, and Bujo also trying and
Meeting has attended with video, block engine routine and solid waste management.
of the matter and
Meet
meet up the all the GP meeting and thereafter, my Lord, come to a decision. Last paragraph 96.
However, no such land the petitioner to respond. The inspection was also conducted. No, what is the grievance of the petitioner?
Grievance is that, my lord, the private respondent illegally, my lord, drains the wastage elements into my pond, which is, my lord, the pollution, my lord, take place, my lord. That's why I ventilated my grievance to the, my lord, Panchayat, but Panchayat and also the pollution control board. But Panchayat, as per the provision, my lord, pollution Panchayat board, Panchayat Pradhan has a power, but despite of that, they have not taken any steps. At the time of hearing, my lord, on 11th.
Where will this water flow? All these years? All these years, what happened?
My lord, in my pond, my lord, they have drainage wastage elements in my ponds, my lord.
You did not raise any objection?
Yes, my lord, I raised my objection, but despite of that, they have not taken any step. That's why, my lord, 11 November, my lord, 2024, my Honorable Justice Ravi Kishan Kapoor is directed them to take a step.
Solid waste public nuisance.
Thereafter, my Lord, he was taken steps and both by petitioner and respondents were
Yes,
not
sir,
harmed,
have
my Lord.
duties to undertake.
Lordship देखा जाए भाई कौन आते
And now they have came, my lord, kindly see the report, waste management. And that is not, my lord, they have pleaded, my lord. And now they have, my lord, pleaded, my lord.
The Gram Panchayat will do it.
Yes, my lord. And kindly see, now they have taken changed their stance, my lord.
However, on the day of your
Earlier occasion, they are
they can
acceptance, my
provide
lord.
the government can
They have
consider
not taken any stand,
Yes, sir, they will
changed
give
the
you
stand.
consumption.
All time they are trying
আমাকে
to
বলে দাও
solve
আপনি
the
আপনি
problem.
Justify the petition.
Who are you?
তুমি জুনিয়র তুমি আমাকে বলতে পারো
বলছি না তুমিও
ও আপনার জুনিয়র
ঠিক
Where is the house of the respondent
আছে
who is sending this waste to the pond of the petitioner?
Lordship, if they can raise what water and every big lordship. There was no drainage system in every village, lordship. And that's why my lord, full body was and trying to solve the problem, my lord. And it will take some time, lordship. And in the meantime, my lord, it is the wall to protect the water.
Who will protect?
My lord, Panchayat trying to solve the problem to my lord.
How? Holding meetings?
Meeting and thereafter, my lord,
No,
private
no, it is
respondent and
I have gone through the report. It is just passing the.
petitioner, my lord, communicate.
No, no,
Okay,
no.
my lord, but they are not coming to appear the meeting and lordship.
The law does not say that for this liquid waste management, the petitioner or any of the plot owners had to provide a land. Law does not say so. So why did the Pradhan approach for a land?
Panchayat approach, my lord.
So you find out. You find out.
And lordship, at present, my lord, nobody is ready to give their land, lordship. Nobody. And that's why, my lord, the problem was solved to the referred to the my lord higher authority for funding to purchase the land, lordship.
Is there any time frame within which this has to be made?
Lordship.
There is no such manner, honestly speaking, in act manner, there is no such time frame. But it is a duty income related upon the Panchayat
Obligatory
Pradhan.
duties, yes.
But they have not acted upon the that's why, my lord, earlier occasion, Honorable Justice Ravi Kishan Kapoor directed them. But despite of that, they have not taken any step. They are in contempt, my lord. Let them Pradhan be present here, my lord.
The orders will be passed against the Gram Panchayat.
That will serve the purpose.
Being response number 7 and response number 8. Under section 19, the responsibility will have obligation to maintain and manage. কি ওটা?
That's the money. Then is the
Who has given this? मेरे के दिया मेरे के दिया Has the respondent made any soak fee?
My lord, here already told already my lord told.
Made.
But my lord, he was not taking a step.
Instruction is always
No, 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 sir.
Then you take steps for you identify the land and make a soak fee. Within a stipulated period, you do it. 6 months is a too long period. 6 months.
And then pond will be filled up.
Within a period of 1 month, you make that. Enough time. From November 2024, this is going on. No, after on 7th February 2024, 2025, they attended the meeting. It was resolved that the respondent will make a soak pit in his land. And now you cannot report that whether this has been constructed or made or not. No, why the BDO has not inquired into the fact? Wait, why the BDO has not inquired into the fact that there was a proposal from the respondent that he will make a soak pit in his area? The report of the BDO does not say that he has inquired into such fact. Why? The last paragraph says that now since their land is not provided, so we cannot do it. There is no reflection of the meeting on 7th February. Who will make this? Gram Panchayat?
Yes, madam. Panchayat Pradhan.
Panchayat Pradhan.
No, my lord. But I am objecting this because the pond is going to fill up rapid.
Awesome.
It's further.
Where is your representation?
Well, representation dated.
Page 14.
Yes, my lord. Page 14. Page 14.
This writ petition is filed for consideration of representation of the petitioner dated 24th June 2021.
Yes.
It is alleged by the petitioner that the private respondents are illegally draining the toilet waste into the pond belonging to the petitioner. The representation was made by the petitioner before the Pradhan Itechuna Hanyan Gram Panchayat, respondent number 7. However, no steps were taken, hence this writ petition. By order dated 11th November 2024, upon hearing the respective parties, following direction was passed in the present writ petition. Eat থেকে illegal activities. The state respondents to Block Development Officer Pandua Development Block has filed report dated 12th February 2025. It transpires from the aforesaid report that pursuant to the order passed by this court, the petitioner as well as the private respondent was called on for hearing. However, since no land could be provided for construction of waste management project, the same could not be executed. Section 19(2) within bracket O provides that the Gram Panchayat has a obligatory duty to maintain environmental sanitation, including promotion and management of solid and liquid waste and prevention of public nuisance. In light of the above provision, the respondent number 7, Pradhan region, is directed to take appropriate steps owner representation is considerable. We consider the representation. Directed to consider the representation of the petitioner dated 24th June 2021 and take steps to maintain the solid and liquid waste and prevent public nuisance as alleged by the petitioner within a period of 6 weeks from date of communication of this order. The advocate for the petitioner is directed to communicate this order to the Pradhan, respond number 7. With the officers
That that SOC has not been prepared. If Malat they are reluctant to prepare the SOC, the Pradhan will Malat again Malat say that the we will not do that. Pradhan
What
will
do
be
that?
given there.
Yes.
They say, my lord, that the SOC has not been prepared despite of the meeting. If my lord, the private respondent again SOC, he is reluctant to making any SOC.
So he will find out. He will find out. Gram Panchayat will find out where to make a SOC.
Then the direction should be given.
Take appropriate steps for management of that by identifying appropriate land.
Because they
he will identify the land and take appropriate steps in terms of section 19. ওটা লিখতে হবে না, ওপরে বলে দিয়েছি।
Pradhan shall identify the land.
It may be soak pit, it may be other way.
Yes,
whatever, that should not come to your land or pond. They will prevent the public nuisance. Huh? Dispose. আর এটা রিপোর্টটা কে ফ্রিতে রেখো?
Item number 182.
Private spot.
Matter relates to the appointment post of Asha
Asha worker. Yes.
The petition and the respondent I applied for the
This was heard.
It was hard before my lord.
Both the parties have filed the written note.
They have filed their opposition, my lord. Yesterday, this was taken up by your lordship when Mr. HON'BLE appeared for the state authority and I appeared for the private respondent. We were making argument. Since my learned senior friend was not there, it was posted today.
Asha workers are appointed under which scheme? This is a scheme.
The scheme is itself known as Asha.
Asha.
Accredited social health activist.
Yes. Yes, sir.
There was an advertisement at page 36, my lord. The respective of number 4 had made an advertisement for filling up the post of Asha Kurmi.
Page 36.
Page 36, Anisha P2, my.
Yes.
But kindly come to clause 4. প্রার্থীকে অবশ্যই মাধ্যমিক বা সমতুল্য পরীক্ষা অবতীর্ণ হতে হবে। মাধ্যমিক বা সমতুল্য পরীক্ষায় অকৃতকার্য প্রার্থী ও আবেদনকারী হিসাবে বিবেচিত হবে। এক্ষেত্রে মাধ্যমিক বা সমতুল্য পরীক্ষা প্রাপ্ত নম্বরের ভিত্তিতে বিচার করা হবে। উচ্চতর শিক্ষাগত যোগ্যতা থাকা প্রার্থীদের উচ্চশিক্ষার জন্য কোনো মূল্যায়ন বা বিবেচনার সুবিধা থাকবে না। That is a specific stipulation in the advertisement itself, my lord. Question is whether it will be complied with or not. My lord, according to this clause, the petition before lawsuit obtain the highest marks in the Madhyamik examination. And if a lawsuit kindly come, page 56, my lord.
Yes.
And the marks obtained by my client 360 with both subject. But that was subsequently they have alleged regarding revised guideline. Revised guideline would be at page 77. This is dated 27th of June 2012, much prior to the advertisement made by the respondent of 4.
Now, what is there?
Advertisement was dated 3rd of January 2022, and this revised guideline is dated 27th of June 2012. Your lordship kindly come to page 78.
This revised guideline has no application so far as this advertisement is concerned.
Yes, according to my humble submission, because if the revised guideline would have been given back to, then this advertisement is of no consequence. And it was specifically stipulated highest marks obtained by the candidate will be the guiding factor. Marks obtained by this candidate in the Madhyamik or equivalent examination 90% weightage. That was not the stipulation in the advertisement itself, my lord.
Where it is?
Page 78 at the top. D3.
Based on marks obtained by the candidate Madhyamik or equivalent weightage, score in the 10%.
Therefore, my lord, the advertisement made dated my lord 3rd of January 2022, and the revised guideline dated 27th of June 2012 is self-contradictory. The respondent for, my lord.
No, this 22 is to be read along with 12.
No, cannot be.
Huh?
Supreme Court said cannot be.
Cannot be.
Yes. Supreme Court said on the date of advertisement, The date, the advertisement itself is the guiding factor. I'm coming to the citation, my lord. They could have said so in the advertisement itself, my lord.
In the advertisement that is there, my learned friend is misleading this code. The first
No, I've read it. That's why I'm asking.
that, well, scheme is at page 78.
Let him complete.
Yes, ma'am.
Yes.
So the petition before lordship obtained marks, my lord, 360, and the respondent 5 without fourth subject, 342.
His mark sheet is at page. Mark sheet of respond number 4.
Well, 83, page 83, my lord, the marks of obtained by respondent 5 is 342. There is 82, my lord. He had no fourth subject, could not be, no marks could be added, but the petition for lordship,
This is in Uchcha Madhyamik, not Madhyamik.
Madhyamik, my lord.
What is her name? Madhyamik, yes. 342.
342, my lord.
Hmm. Yes.
Well, a question came up for consideration before this honorable court, whether additional subject obtained, marks obtained the additional subject would be added as a qualifying marks or not. This honorable division bench of our court, my lord, have declared the law, yes, it must be added. And I have handed over the judgment, my lord, if your lordship kindly.
This 342 is without additional subject.
342 without additional subject.
And your 360?
With fourth subject, with additional subject.
And without additional subject, his is 325.
Yes, yes. সেটা বড় qualifying marks তো বটে। Well, may I hand over that judgment, my lord? সঙ্গে দেয়া যাবে।
Paragraph?
Paragraph 8. 2073. 477. May I read, madam?
Yes.
It finds substance in the contents of Mr. Samondo, the learned advocate appearing on behalf of the writ petitioner, that the process of selection in the case before us having been initiated in the year 1995, the clarification issued by the concerned officer of the Government Union of India in the year 1996 cannot guide the present case, even if we assume the sake of argument that such clarification has the force of law, overriding the rules framed by the statutory authority holding the examination. It appears from the advertisement for the post of concern that the candidates should pass Madhyamik examination or its equivalent. It further appears from record that the position of a candidate in such examination is decided after taking into consideration the marks obtained in the additional subject excluding the pass mark of 34. The various categories of the divisions are conferred upon the examinees after taking into consideration such marks obtained in the additional subject. Therefore, there is no reason why the added marks obtained by the candidate from the marks obtained in the additional subject should not be taken into consideration for their assessment. In the case before us, the private respondent failed to secure even the pass mark in the additional subject. As a result, no mark was added to the credit, whereas the writ petitioner has obtained 65 marks in additional subject. 65 minus 34 is equal to 31 marks were added to his aggregate marks. The Board of Secondary Education, a statutory authority, having decided to take into account the marks obtained in the additional subject for the purpose of assessing his position, the merit list, we find no reason to ignore such decision in the facts of the present case. Therefore, my addition of the beyond the my lord cut-off marks, the addition marks, my lord, cannot be ignored. It has to be taken into consideration. And more so, my lord. Madam,
The agent.
the selection in that case matter was set aside.
Subject.
And the petition was
In fact, the graduate
was directed to be appointed in the post.
The petitioner is 28 marks in the Yes.
Now the question comes, my lord. What will be the position regarding selection? According to my humble submission, my lord, the date of advertisement is the date which is to record to be followed. My lord, I am relying on the judgment of the 3 judges bench of the Supreme Court, my lord. This is 1991 SCC 411. Kindly come to paragraph 6, man. And one words, my lord, the quoted portion, if your lordship kindly come. Page 417. I'm taking 6 lines from the top, my lord, in the quoted portion.
Yes.
The process of selection under section 16F of the Act, commencing from the stage of calling for applications for the post, the date on which the director becomes entitled to make a selection under section 16F code as is stood then, is the integrated one. At every stage in that process, certain rights are created in favor of one or the other of the candidates. Section 16F of the Act cannot therefore be construed as merely a procedural provision. It is true that the legislature may pass laws with retrospective effect subject to the recognized constitutional limitations. But it is equally well settled that no retrospective effect should be given to any statutory provision so as to impair or take away the existing right unless the statute either expressly or by necessary implication directs that it should have retrospective effect. But it's clear, my lord. Revised guideline of 2012.
Yes.
And paragraph 7, my lord, the first sentence, my lord. In view of the above, the appellant's selection, an appointment could not be held as illegal as the process of selection had commenced in 1983, which had to be completed in accordance with law as it stood at the commencement of the selection. See, another judge, my lord, this is 1990. This is 1993 SCC, page 157. my lord. I am relying on paragraph 11 and 13. Paragraph 11. There is yet another aspect of the question. Another advertisement is issued inviting applications for direct recruitment to a category of posts, and the advertisement expressly states that selection shall be made in accordance with the existing rules or government orders, and if it further indicates the extent of reservations in favor of various categories, the selection of candidates in such case must be made in accordance with the then existing rules and government orders. Candidates who apply and undergo written viability test acquire vested right for being considered for selection in accordance with the terms and conditions contained in the advertisement, unless the advertisement itself indicates a contrary intention. Generally, a candidate has a right to be considered in accordance with the terms and conditions set out in the advertisement, as his right crystallizes from the date of publication of advertisement. However, he has no absolute right in the matter. If the recruitment rules are amended retrospectively during the pendency of selection, in that event, selection must be held in accordance with the amended rules. Whether the rules have retrospective effect or not primarily depends upon the language of the rules and its construction to ascertain the legislative intent. The legislative intent is ascertained either by express provision or by necessary implication. If the amended rules are not retrospective in nature, the selection must be regulated in accordance with the rules and orders which are enforced on the date of advertisement. Determination of this question largely depends on the facts of each case, having regard to the terms and conditions set out in the advertisement and the relevant rules and orders. If there is any confusion, we would like to make it clear that a candidate on making application for the post or the post pursuant to an advertisement does not accord a vested right of selection, but he is eligible and otherwise qualified in accordance with the relevant rules and the terms contained in the advertisement. He does acquire a vested right of being considered for selection in accordance with the rules as they existed on the date of advertisement. He cannot be deprived of that limited right on the amendment of rules during the pendency of the election unless the amended rules are retrospective in nature. Another judgment matter, this is 2007-10 SCC 627. Well, kindly come this judgment matter, paragraph 9. Paragraph 9, manner, the last sentence. In our view, the office memorandum dated 6th of November 2003 cannot have or could not have retrospective effect as the appellant would be governed or covered by the date on which the applications were invited to fill up the post of Assistant Administrative Officer on 30th October 2003, and also for the reason that no retrospective effect has been given to the said office memorandum. But is it clear? And paragraph 10 also, my lord, this is reiteration of the judgment of this habeas court. My lord, I have cited, my lord, 1993 SCC 157. In the Devin Katti versus Karnataka Public Service Commission, this court has held that her selection process has been initiated by issuing an advertisement inviting applications. Selection should normally be regulated by the rule or order then prevalent. And also, when advertisement expressly states that the appointments shall be made in accordance with the existing rule or order, subsequent amendment in the existing rule or order will not affect the pending selection process unless not the intention is expressly or impliedly.
Mr. So and so learned advocate for the petitions. Due to paucity of time, the hearing could not be concluded with this matter on. However, hearing লিস্টে নিয়ে চলে যাই, এটা নোট দিয়ে 26th এটাকে যেহেতু স্টার্ট হয়ে গেছে হিয়ারিং লিস্টে নিয়ে যাও, ওখানে একটা নোট দিয়ে দেবো যে এত থেকে হিয়ারিং।
On what of argument I have submitted on the other
হিয়ারিং ট্যাবটা কি এরকম রেখে যাবো না ব্যাগে ঢুকিয়ে দেবো? You will conclude. Thereafter, you make your distinction with regard to the judgments he has referred to.
I don't know. I have the lordship's leave for the last occasion I had mentioned, your lordship asked me to give a notice and then come. For
What is it?
almost 5 months in a judgment upon admission, our side has not filed the AO, in spite of the peremptory extension, my lord, obtained by them. Since then, it was supposed to be filed on 9th of January with them. Today we are on 17th, they have not. In spite of repeated notice.
There was a
Let it
direction.
appear as
Ki acha already.
motion unopposed.
What was the order first?
On earlier occasions, they had been adopting dilatory tactics while filing the written statement as well. Same things they did again on personal accommodation. It's used to seek time and prefer appeal. All sharp practices obtained and adopted by them. The original defendant has expired in 2008. We are in 2017. After 5 years, heirs have no right. Very short point. They have no defense whatsoever. Original defendant.
This is a suit for?
Suit for recovery of possession, my lord, and injunction and other reliefs.
When was the first direction issued for filing of the affidavit in office?
It was on the first day after puja reopening, my lord. It is there, my lord. It was on 4th of November, my lord. They defaulted. Then your lordship granted extension on 9th of December for another 4 weeks. The application was served on September, my lord, 17th September. We are on 17th February.
देखिए
Would it appear as motion unopposed, my lord?
No, it will appear under to be mentioned. I'll see what is in the records thereafter. We'll fix it.
Can I ask the copy of the orders?
Let it appear under the heading to be mentioned. What is the Asha, to be mentioned? The records টা পেলে তারপরে করবেন। Huh?
May I permit to mention one more?
Yes.
Leave be given for filing on a receiver's account.
As soon as the records are received, it will appear. Don't worry. Yes.
Leave be given for filing my receiver's account.
Have we permitted to mention, Lordship, the interim order that has actually
Ah.
expired yesterday, Lordship. I had come, but your Lordship wasn't taking up original side mentioning yesterday.
Expert record আছে দেখো। Other side given notice.
I am for the defendant, my lord.
Six. ওটা নিয়ে অর্ডারটা করে দাও না? You have filed your affidavit in office.
We have already filed our opposition, my lord. Lordship, pleadings are complete, my lord. It is ready for hearing.
আসো। এটা item number 106 এ আছে?
It is appearing as 106 in the monthly list, my lord.
Mr. and Solaner advocate appearing for the plaintiff seeks for extension of the interim order granted earlier on 15 December 2023. In view of such submissions, interim order granted early on 15th December 2023 is extended till the end of March 2025.
Lordship, actually, the matters are pending for a long time, Lordship. If a Lordship can up.
Let it be there in the monthly list, we'll see.
Grateful.
Document. Question.
My lord, I appear in this matter, my lord, for the defendant number 1. My lord, I have 2 submissions to make, my lord. My lord, 1, your lordship had by an order dated 9 December 2024 and thereafter by an order dated 14 January 2025 had directed the partition commissioner to file a statement of accounts in the form of a report.
Your lordship directed the receiver. The word was receiver. I have prepared that particular
My lord,
intent to file it.
Keep it with you.
my lord, that statement of accounts, my lord, along with, my lord, there was a previous order of Justice I.P. Mukherjee passed on 22nd April 2014. My lord, by that order, his lordship had then directed. Well, may I just hand over a copy? Had directed the partition commissioner to prepare statement of accounts and circulate it amongst the parties. My lord, that part is at the last page.
Yes.
My lord,
Yeah, propose this, my lord, I just submit. Pursuant to that order, every year accounts are being filed and approved. And my lord, whenever the parties are seeking that so Subramshu Ganguly also demanded from me the copies I have.
my lord, my respectful submission is, my lord, these accounts have not been circulated amongst the parties. My lord, today what the statement of accounts your lordship is looking into, my lord, we are not aware. My lord, we do not have copies of. So, my lord, my respectful submission is.
But he says that he is circulating the copy.
My lord, my
whenever it is being demanded.
I am for the plaintiff numbers 3A to C. My lord, I also agree to this submission that no copies have been served in the interregnum period on us.
But if you can at least look into the copies and then at least be in a position to at least. Yes, my lord, the direction of Justice Mukherjee was very clear. Every subsequent year, parties have to receive a copy of the statement of accounts and the same shall be also filed before the court. My lord, may I just place that part?
Serve a copy first. No?
If we can look into it and then, my lord, if you have anything to draw your lordship's attention to, my lord, we will.
But today, my lord,
Sure.
I do not want to carry this receiver's report as per your lordship direction. May I file it?
Sir, copies may be also.
Yes, maybe I have. I have come prepared. Everything is written here, my lord. My lord, I may point out 3 things, my lord. One of the very important things.
Let them first go through that.
No. Let them go through that. My lord.
Thereafter, you make your submission.
Very well. May I file it?
My lord, this your lordship perhaps is being filed, my lord, in terms of your lordship's order dated 14th January 2025, where your lordship makes reference to the order dated 9th December 2024. Yes. My lord, may I? Anjanda. On the 9th December is the first order passed by your lordship. And the last 2 paragraphs on page internal page number 2.
He is retired to remain present and he also retired for his form of report of the Johnson disability. Okay. Learn it.
Well, is it your lordship's pleasure to me to hand over the copies of this report to everyone?
Yes.
Yes. You are Commissioner for Partition.
Commissioner for Partition and Receiver.
Commissioner for Partition and Receiver, Mr. Gautam Chakraborty, files report pursuant to the order dated 9 December 2024 and 14 January 2025, which is taken on record. Copy served. Miss Sulogna Mukherjee, learned advocate for
Defendant number 1.
defendant number 1, submits that she shall place her submissions on the report of the receiver after going through the same. কবে দেবো?
I keep. My lord, only one thing, my lord, the accounts
কবে
also, my lord.
একটা ডেট দিয়ে দেবে, ফ্রাইডে হয়তো।
If I may submit, my lord, the report contains this. The report contains the particulars of whatever steps have been taken. The accounts
Yes.
or the scrutinized statement of accounts is not supplied with the report, my lord. That may be necessary for the purpose of ascertaining the
Mr. Chakraborty,
May I clarify? Here, my lord, statement of account in the form of report as per direction, as far as I have been able to understand. My lord, if your lordship so direct me, right, so far, all the my lord accounts, whatever has been my lord approved by the honorable court, starting from 2011, I will be able to supply copies.
My lord, yes, my lord, that.
I will be.
My lord, that will be in terms of the order of Justice Mukherjee of 22nd April 2014.
My lord, I will be. I will
But
be
that
supplying.
is the accounts perhaps your lordship would have been looking into, my lord, had the department put the file, the records before your lordship. Lord, copies of that also may be circulated. My lord, we shall come back.
all the previous, then you have to say in which period he has not given the copy, so that that can be specified in the.
Sir, I can house
My lord,
the
last 5
lordship,
years.
my lord.
Last 5 years should be
Very well.
sufficient.
Last 5 years, I will settle.
And my lord, the particular statement, the direction was in the December and January orders of 2025. Insofar as this particular report is concerned, at least the accounts on the statement of accounts on the basis of this report is prepared, maybe handed over. We may write to him, he can hand it over, my lord, because or in court, my lord, because the reason is without the particulars, the exact dues and the outstanding and the manner in which the payment has been made, well, it will be very difficult to ascertain. There are four or five properties. I am not trying to discount the process that has been already pursued. I'm only requesting
Lord, I have
facilitate.
stated in my report every details, including the present balance, and my lord, a sum of rupees 6,17,470 is being, my lord, kept in the account because of the direction by the income tax authorities for a dispute of the period of 2015-16 income tax.
No.
My lord,
That
what
is-
I'm saying, my lord, is this, that
that is what you have stated in your report, but that should be in the form of an accounts, what you have received and what you have, I mean,
My lord, in that case, my lord, the statement of account, whatever is in the passbook, well, I can supply to everybody.
whatever you say that last 5 years you will supply. What are you preparing?
For the last 5 years are concerned, my lord, whatever statement I have filed before the Honorable High Court at Calcutta, I will supply that.
That will be sufficient?
My lord, I am on, that will be sufficient for the timing, indeed. That is in respect of the 2014 order, which was not been complied till date. But I am only on the point of the present report which has been filed. My lord, the learned receiver has already relied on documents to
Mr.
prepare it.
Ratul Das, learned advocate for
I am for the plaintiff numbers 3A to C.
3A to C.
3A and B, sorry.
Plaintiff numbers 3A and B submits that the report does not contain the statement of accounts as directed by the court. Mr. Chakraborty submits that he shall circulate the copy of the statements as required by next week,
Whatever, my lord,
as well as the statement of accounts furnished before the honorable court pursuant to order dated 22nd April 2014
the last 5 years.
of the last 5 years. Financial year, last 5 financial years. List this matter. Right, Attorney?
For the last 5 years will be better statement, my lord, because up to August every year.
It is in financial year, last 5 years.
I am not raising any.
13th March.
I am not raising any apprehension on this document. I am only.
No, it's all right. Since you want to have a look to the accounts and also assist the court, let's have a, yes.
My lord, instead of 13th March, my lord, 13 বললেন তো হ্যাঁ my lord instead of 13th March my lord will it be your lordship's pleasure to put it in the next week the following week of March
20th March.
20 হবে my lord on 20th
March of
I'm so
And take back these copies of your.
Yes.
আমাদের তো এটা আছে রেকর্ডস আছে তো হ্যাঁ
my lord the order dated 22nd April may be retained my lord that may not be
yes
the remaining two I'll
এইটা রেখে দিন আর এই দুটো দিয়ে দিন 22nd April অলরেডি রেখে দিন
Lord, I will supply the copy.
Yes.
I beg to appear on behalf of the plaintiff.
Status check করে পরিষ্কার করা যাচ্ছে না যে অ্যাসাইন পার্টনার বা কিছু অনেক কিছু বলে স্ট্যাটাস করতে হবে যদি একজনই করেন তো ঠিক আছে
পাসওয়ার্ড হয়ে গেলে
ঠিক আছে আমরা সব লিস্টটা পাবলিশ হয়েছিল তাতে কি কমিটি রিপোর্ট দিতে পারি
তাহলে কি প্রত্যেকটাতেই ওই স্ট্যাটাস রিপোর্ট নিয়ে তারপর করবো
ঠিক আছে স্টেট রিপোর্ট কমপ্লিট
department is directed to what was this status of the suit
Your Lordship, I have been briefed just this morning. The client called me up. We have to take instructions and reconstruct the record. We don't have the records with us, Your Lordship.
department is directed to furnish a status report within period of 3 weeks করে 3 weeks list this matter after 3 weeks huh?
February 2025 one week which
লিস্ট আসছে না সেটাও কি করবো 2 সপ্তাহ পরে করবো নাকি 3 সপ্তাহ ঠিক আছে the operate huh? The matter was listed under the warning list on 13th February 2025 and is appearing today in the regular list. সেম জিনিসটাই না অন্য এগুলোতে দেবেন অন্যগুলোতে যেগুলো ঢাকবে এরপরে ওল্ড সুটসে সবটাতে স্ট্যাটাস রিপোর্ট করবে None appears on behalf of the status report. Same. Date of warning list same though? Same. Same order.
5, 6, 7, 8, 9, 8, 7.
I'm appearing on behalf of the plaintiff in item number 11. I kindly beseech Your Lordship to please list this matter anytime after 3 weeks. This is a
প্রথম অর্ডারটা
1994.
যেটা হয়েছে ওইটাই করে দেবেন প্লেন্টিভের রিপ্রেজেন্টেশন আছে আর যেটা কল ফর স্টেটাস রিপোর্ট বাকি 11 হুম সেম অর্ডার সেম অর্ডার
I am for the applicant in this matter. I am for the receiver. Matter has been assigned to your bench and Mr. Rudradev Chaudhary was Chaudhary was appearing in this matter.
Your Lordship heard this matter.
Yeah.
The transfer
Yes, Your Lordship heard this matter or 2 days, my lord. Thereafter, my lord, Your Lordship release the matter and thereafter assigned before Your
It has been
Lordship.
assigned to you.
That matter, my lord, the public.
this matter is appearing under the heading to be mentioned. Upon assignment by the Honorable Chief Justice on 18 December 2024. Yes.
Lordship has already heard us at length. The observations are also recorded in the Lordship's last order dated 10 December 2024. Lordship has observed what is coming out from the records. And then the Lordship had asked for placing this before the Chief Justice, had come back for your Lordship. So now the only thing left is your Lordship has seen the prayers. It's recorded in the order itself. We are seeking cancellation of that sale. Now the learned special officer is present today. His contention at time of that hearing, earlier hearing, was that he has nothing to do. If Lordship directs, can be cancelled. If
I have
Lordship
already
doesn't.
submitted for your lordship. As per court direction, I do that. If as your lordship pass the necessary order, I will do.
So if it can be done today, if Lordship on, or not any day, as I leave it to your Lordship. Lordship's convenience. Lordship says today, any day. Subject to Lordship's convenience, we can.
Director Guru. Where is Mr. Chaudhary?
Yes, he is my leader. Today he is not present, but he had indicated some dates. If Lordship, since it is coming under two, we mentioned it has to come under either forward.
Date बोले. I'll list this matter on 26th, 25th.
Instead of 26, can it be on the 27th? দুটো দিন বাদ।
March first week দিন।
4th March, yes, 4th March. Grateful. But should we also come up with a written notes of argument or
No, not required. I've taken note of it. Only that you are the original purchaser and without.
That's a small issue. That's recorded in Lordship's last order. So very well. Grateful.
My lord, I appear on behalf of the plaintiff, my lord. My lord recalls this is that matter, my lord, in which directions of sale was sought for by us regards the sale of certain properties, my lord. My lord, on the last occasion, my lord, there was another application which was disposed of by your lordship. Yes, my lord. So, my lord, on that day, my lord, we had submitted before you that though the procedure of the sale has already been completed, as in the bids have come, still we had sought for a time of 1 month before the confirmation of sale is published in finality. My lord, this matter has, I guess, my lord, come up in regular course. So, my lord, I was beseeching your lordship to kindly.
No order need be passed.
Yes, my lord. So,
Returnable by a lordship order of January.
January, my lord.
After that, 2 orders were passed by a lord on 2 separate applications. And in the meantime, the receivers are taking steps as per your lordship's last order.
There is a
That is what we
modification
had
to the
sought
order
for.
passed.
Yes,
on
my
the
lord.
date the matter was heard with regard to GA20.
GA25, my lord.
18 was modified.
18 was
Time
modified.
was extended.
Yes, time to complete the sale was extended by 1 month. It was supposed to get completed by the 10th of February. So we had sought for a time of 1 month's extension from your
So
lordship.
they extended for 6 weeks.
6 weeks, yes, my lord. 6 weeks.
Okay.
The lordship can keep this matter returnable in April.
Any order will be required to be passed this day.
My lord, that is up to your lordship, my lord. If my lord,
it
it would be beneficial, my lord, if actually my lord passes a direction. If that is on record, my lord, then we can act upon it, my lord.
No order need be passed.
But may I receive, because I on behalf of the receiver will have to file a report, because in the meantime, I expect that the sale proceeds should be forthcoming. So the lordship can keep this matter on a particular date in April. Common sir to your lordship, then it will be convenient for us. Because 6 weeks from February, no, 6 weeks from February.
Monthly April. No order need be passed. List this matter in the monthly list of April 2025.
I'm grateful, my lord.
Number 23.
Lordship, I'm for the petitioner.
I am appearing on behalf of the defendant.
Yes.
Lordship, in this suit, GA6 was filed by the defendants and it was dismissed by the order dated 24th January 24. which was challenged in a division bench
24th April.
April.
Ah.
And 24th January. By order dated 24th January, GA6 was dismissed by a single bench order.
24th April it is.
Your Lordship will kindly see the 24th April's order, which should be, my Lord, in my most humble submission, the last time when the suit was taken up by Honorable Justice Sugata Majumdar. That was the time, my Lord, when a matter was pending before the Honorable Supreme Court, which, my Lord, had its genesis from an application which was taken out on behalf of the defendant before the trial. Because, my Lord, the Honorable Division Bench had held, and that portion, my Lord, is quoted in the order of 24th April 2024. If the suit has become academic and it goes to the jurisdiction of the court, court would no longer retain jurisdiction to adjudicate it. Once it is a jurisdictional issue, it can be tried as a preliminary issue before all the other issues. The preliminary issue may not only be an issue of law, but an issue of fact and law rolled into one. Now, my Lord, after that, the plaintiff has not taken much steps. But the Supreme Court now, my Lord, has passed an order. I am handicapped. I don't have a copy of that order, my Lord, with me. Here, order.
May I hand up the order of the Supreme Court, which was passed? Lord, all this arose out of an application under Order 7, Rule 11. And Lord, that was dismissed by this court. Division bench said that that should be, Lord, taken up as a preliminary issue under Order 14. Then, Lord, the matter went to the Supreme Court. May I place the order of the Supreme Court? Kindly come to paragraph 3. Nonetheless, we clarify that the trial court single bench shall be at liberty to proceed with the suit itself in accordance with law, having regard to the developments which had taken place pending the suit. Both the parties shall also be liberty to file appropriate proceedings before the trial court single bench as may be permissible under the law, and if such proceedings are filed, the same be considered without being influenced by the observation made in the impugned order passed by the division bench. We further clarify that we have not expressed any opinion on the merits of the case. Subject to the above, the special petition is disposed of. Now, my Lord, what had happened is, this is a property which is not situated in a prime location. Now, my Lord, a lease was granted pursuant to, this is a property of the DT. Pursuant to the leave granted by the court, lease was granted in favor of the lessee. Now, my Lord, what happened is that lessee defaulted in paying the lease rent. So, my Lord, we came up to the court and there are two different set of orders the court passed on the basis of the mutual consent of the parties. Now, my Lord, the suit was kept pending. Now, what happened is that despite this order, Lord, they had been defaulting in paying rent. I think from January 2022 onwards or January 2023 onwards, there is a default constant. Now, Lord, we filed an application seeking, Lord, occupation charges in the pending suit because the suit is pending. Now, Lord, initially, a third party, Lord, filed an application pro interesio seeking, Lord, leave to intervene. That was rejected. Then, Lord, keeping this application pending, an application under Order 7, Rule 11 was passed. Now, Lord, we are the owners, the DTs are the owners, the Shivaites are before your Lordship. Lord, the issue is that there is a pending application called GA number 6, where, Lord, we have asked for payment of occupation charges in terms of the order passed by this court. Okay. And on, Lord, terms of settlement filed by the parties. This is the scope of the application in GA6. If your Lordship, Lord, kindly.
So this occupational charges they will pay. They have consented to that.
No, they have not. They were contesting that on the ground. First, they said that the suit has become infructuous by passage of time. So, Lord, Order 7, Rule 11. That was rejected by the court. Then, Lord, they bring in a third party saying that I am a sublessee. Therefore, I have a right. Now, Lord, this is a suit is for eviction. sublessee has no right. There is no contractual agreement between the landlord and the sublessee. So, my lord, that application was rejected. Then, my lord, Order 7, Rule 11, an appeal was preferred. That appeal, my lord, the division bench said that you try this issue because they said that the suit has become infructuous by passage of time. They tried this issue as a preliminary issue under Order 14. This matter goes to the Supreme Court. And now, my lord, we are back that Supreme Court says that we will be at liberty to file whatever applications we can in law.
But then a preliminary issue has to be decided on the basis of the evidence also.
But the issue, if your lordship frames the issue, it has to be decided because, my lord, the suit is pending. But, my lord, pending those, my lord, even if your lordship frames an issue, my lord, the occupation charges.
This application has to be heard out.
That has to be heard out. As of today, 3 crore 92 lakhs is pending, outstanding. So, Lord, my request to your lordship is
very authority of the state as because if this court is being then you already sworn.
Lord, my reading of the order of the Supreme Court is, if your lordship, Lord, kindly take paragraph 3. They don't interfere. Firstly, my lord, paragraph 2, it says, having regard to the facts and circumstances, we are not inclined to interfere with the impugned judgment and order passed by the High Court. Has your lordship found that? Then, my lord, paragraph 3. Nonetheless, we clarify that the trial court single bench shall be at liberty to proceed with the suit itself in accordance with law, having regard to the developments which had taken place pending the suit. So, my lord, the subsequent facts should be taken into consideration. Then both the parties shall also be at liberty to file appropriate proceedings before the trial court, single bench, as may be permissible under the law. If such proceedings are filed, the same be considered without being influenced, etc. Now, Lord, there is no impediment in hearing out, Lord, the application under being GS6. The order of the Supreme Court says that it may not be by a preliminary issue, but in paragraph 3 it says, but the court will take into consideration the developments which have taken place pending the suit.
After passing of the order by the Honorable Supreme Court, what happens to the direction of the appellate court?
Lord,
does it stand?
The direction of the appellate court, my reading is reading paragraph 3. Your lordship kindly sees.
Proceed with the suit.
Proceed with the suit itself. Liberty to proceed with the suit itself in accordance with law, having regard to the developments which had taken place pending the suit. Because their application for rejection of plaint was on the ground that during the pendency of the suit has become infructuous due to the changed circumstances.
Now, the court holds the single judge on 24th April. It says that since preliminary issue relates to very authority of this court, as observed by the division bench, this issue would be addressed first.
Yes.
If this court is bereft of its jurisdiction, then any order disposing of 6, that is occupational charges, prior might be an infructuous act.
That's right. But kindly see the date of that order.
24th April.
And Lord, this order was passed on 17th of December 2024. This is subsequent. At that stage, Lord, the SLP was pending before the Supreme Court. That's why I say that now, because of the order of the Supreme Court, kindly hear out my application being GS6.
Just a query.
Yes.
Suppose I hear out your application, then what happens to the preliminary issue which has been dealt with by the appellate court?
Yes.
That you decide the preliminary issue first.
Yes.
If the court
That is diluted now because of this order of the Honorable Supreme Court. If your Lordship sees paragraph 3, your Lordships will find the court says that you proceed with the hearing of the suit in accordance with law, having regard to the developments which had taken place pending the suit.
Okay.
So, Lord, my reading of this order of the Supreme Court is that preliminary issue point now, Lord, stands diluted by reason of para 3.
Yes.
Milord, your Lordship, Milord, has been shown the appellate court's order. That was the order.
Just one Lord line which I missed. My learned junior correctly points out. Kindly come to the page 2.
The impugned order before the Honorable Supreme Court was the appellate court's order.
Yes.
Yes, page 2.
Page 2, kindly come to the second line. Such proceedings are filed, then the same may be considered without being influenced by the observations made in the impugned order passed by the division bench.
Yes.
I say that there is no impediment in not hearing my application GS6.
Okay. Milord, may I make one humble submission? Your Lordship kindly takes up the order passed by the Honorable Supreme Court. I had the good fortune of appearing there, Milord. Your Lordship kindly see, immediately after the court's title, there were 2 interlocutory applications before the Honorable Supreme Court. One of them, Milord, it's there, appropriate order stroke directions. IA number 210441 of 2024. Appropriate order or direction. This application, Milord, was filed on behalf of the plaintiff, who was the appellant before the Honorable Supreme Court, seeking for release of certain sums of money to the tune of rupees 3 crore. That, Milord, application was not considered by the Honorable Supreme Court. No order was passed in that application. So the contentions raised before your Lordship in GA6 was actually, Milord, agitated before the Honorable Supreme Court. I am not saying res judicata. I am saying the Honorable Supreme Court, Milord, has given liberty to the plaintiff to approach the single judge with appropriate applications in accordance with law. Now, Milord, your Lordship has been correctly shown that it was the order passed by the Honorable Division Bench, which was, Milord, the so-called impugned order before the Honorable Supreme Court. The Honorable Supreme Court did not find any impunity in the order because the order has not been set aside. Following the order, Milord, before the Honorable Supreme Court had upheld, if I may say so, the order passed by the Honorable Division Bench, this Honorable Court, Milord, in the single bench when the suit had appeared, has clearly, Milord, followed what the Honorable Division Bench had passed. Because by that time, the order of the Honorable Division Bench was not upheld by the Supreme Court. Eventually, it is upheld, with liberties given to the parties to approach the single bench with appropriate applications for appropriate reliefs. But the suit must proceed in accordance with law. That is exactly what the Supreme Court has said. Because it was actually the issue relating to preliminary issue, whether preliminary issue should be decided or not, was the issue before the Supreme Court. So that contention, Milord, of the plaintiff has been turned down. And the order passed by the Honorable Division Bench has been upheld because it has not been set aside. So, in my most humble submission, Milord, kindly takes up the Division Bench order once. Other than the portion which has been quoted, Milord, kindly see, kindly comes to page 4, Milord, of the Division Bench order.
Yes.
If the suit, Milord, immediately after the expressions in italics, it reads, if the suit has become academic and infructuous, it goes to the jurisdiction of the court. The court would no longer retain jurisdiction to adjudicate it. Once it is a jurisdictional issue, it can be tried as a preliminary issue before all other issues. This preliminary issue may not be only an issue of law, but an issue of fact and law rolled into one. This, my lord, has been quoted in the single bench order which I had shown. Not interfered by the Honorable Supreme Court, hence I deduce, say, my lord, that it is upheld. What is important, my lord, is the next paragraph, because there the Honorable Division Bench gives directions. We are of the view that the question raised in the application before the court below in GA8 should be tried as a preliminary issue in the suit on the basis of the application and the affidavits exchanged thereto before the suit proceeds any further. The learned single judge may direct documents to be disclosed relating to that issue only, invite evidence to be adduced in court or by commission, whichever the court deems fit and proper, and decide the question as soon as possible. Depending on the decision of the court on that issue, suitable directions may be made, either disposing of the suit or directing that the suit be tried and determined on all issues arising therein. And then, my lord, I'm just skip. At this stage, Mr. Mukherjee submits that there is a pending application, GA6, before this honorable single judge. We say that it should be open to the learned single judge to decide in what order the preliminary issue or the pending application is to be entertained by the court. We request the learned trial judge to decide on the preliminary issue within 3 months from the date, preferably. And then, my lord, the appeal is disposed. So, my lord, liberty was given to the honorable single judge to decide in which order whether GA6 is going to be heard first, or, my lord, the suit or the preliminary issue, which may lead to even the dismissal of the suit. Appreciating this fact, my lord, the learned single judge, Honorable Justice Sugato Majumdar, when his lordship, my lord, had the appropriate determination, has already, my lord, made an observation that it is the preliminary issue which is going to be decided first. I beseech your lordship, my lord, that the Supreme Court has only upheld what has, my lord, been what has fallen in the order passed by the Honorable Division Bench. And this Honorable Court, my lord, the Honorable Single Judge, has already decided which order the parties are to proceed in this.
It will CPC ta dinna.
So, my lord, I beseech your lordship, my lordship may fix any date where your lordship,
order GA8.
Yes, where, my lord, the records of GA8 can be before your lordship, so that we may assist your lordship, my lord, in framing the preliminary issue, and necessary directions can be passed, my lord. Because the order in which, my lord, the suit will now proceed has, my lord, already been passed by the Honorable Single Judge, and there is no application, my lord, for recalling of this order or modification of this order. So this, my lord, has to be followed now. This preliminary issue, my lord, is order 14.
Can a preliminary issue be tried singularly or separately than the other issues
The
involved?
Honorable Division Bench has clarified that.
So this is
Yes.
the order.
No, please. You come to order 14, rule 2.
Yes.
You have the CPC?
But may I place, my lord? Notwithstanding that a case may be disposed of on a preliminary issue, the court shall, subject to the provisions of Sub-Rule 2, pronounce judgment on all issues. Where issues both of law and facts arise in the same suit, and the court is of opinion that the case or any part thereof may be disposed of on an issue of law only, it may try that issue first if that issue relates to jurisdiction of the court.
That's it.
So a part. We are, my lord, only on a part.
So why I'm asking this question? Because there is a direction of the division bench which says that it can be tried as a claim before all other issues. This preliminary issue may not only be an issue of law, but an issue of fact and law also. So
But the Honorable Supreme Court has not interfered with this observation of the
that is what I'm saying.
Yes.
If the order has to be complied, can the preliminary issue be tried? It begins with the word try. So whether we can take evidence on the only on the preliminary issue, that is what I'm asking. Separately tried.
Lord,
God can
Can I-
answer this
can I
academic
react?
question, my lord.
Lord, please see the division bench's order, page 4. After, my lord, all that, kindly see the third last paragraph. At this stage,
yes,
Mr. Mukherjee submits that there is a pending application before the learned single judge. We say that it should be open to the learned single judge to decide in what order the preliminary issue or the pending application is to be entertained by the court. Now, my lord, this was the direction. Now, my lord, kindly see how the Supreme Court deals with this part. Lord,
yes,
considering that, Lord, my lord's reading of Order 14, Rule 2, that, Lord, if it is a point of law and not an issue of fact and law, that can be decided by the court. But if it is an issue which is interconnected with the facts and law, then, Lord, it has to be taken up with all other issues. This is, kindly, my lord, come to paragraph 3. Once again, Lord, I take the trouble of reading it once again. I'm sorry, my lord.
yes.
Says, nonetheless, after saying that they are not interfering with the order of the division bench, then it says, nonetheless, we clarify that the trial court single bench shall be at liberty to proceed with the suit itself in accordance with law, having regard to the developments. That means accordance with law means if your lordship finds that it is intervened with the facts and law, then, Lord, all the issues will have to be taken up together.
So that is true, but the question is, the division bench says that it should be tried at first, and that has been affirmed by the Honorable Supreme Court.
No, that is subject to clarification. My reading, subject to clarification, if your lordship sees, having regard to the developments which had taken place pending the suit, both the parties shall also be at liberty to file appropriate proceedings before the trial court single bench as may be permissible under the law, and if such proceedings are filed, the same shall be considered without being influenced by the observations made in the impugned order passed by the division bench. So your lordship is given a free hand in so far as, Lord, considering whether, Lord, these applications, whether your lordships will consider or not. The, Lord, provision is that even if your lordship frames an issue, it does not debar your lordships to decide, Lord, interlocutory applications. Even if an issue is framed in a suit, Lord, an interlocutory application is filed, your lordships will be entitled to dispose of the interlocutory application. How is it interconnected with the issues? That is what the Supreme Court says. That, Lord, if I file an application, which your lordships can decide, but prior to deciding these issues, Lord, if it comes to a point where your lordships will have to consider the overall situation in a suit in passing an order in my application, your lordship can hear the applications along with the suit. That's another question. But if your lordship finds that the parties had agreed that they would pay certain occupation charges for occupying the property, and they have not paid that, it's simply implementation of an earlier order passed by the court that has got no issues otherwise than the order issues covered by the order of the court. But my humble submission is that Order 14 does not halt the hearing of the interlocutory applications. It merely says that your lordships are, it gives power to my lord to frame a preliminary issue and decide that preliminary issue if it is a pure question of law. that is entirely the discretion of the court. But Lord, here is a case where I'm saying that Lord, framing of an issue, even if your Lordship frames an issue, it does not debar me from filing an interlocutory application. And it does not debar your
You
Lordship.
have to decide the preliminary issue at first.
Lord, the framing of preliminary issue, according to
Not
my
only
humble
framing, deciding that issue.
Lord, my humble submission is that pursuant to the order of the Supreme Court, that direction of the division bench stands diluted. Because, Lord, if the issue has to be decided first as a preliminary issue, then, Lord, all this liberty of filing applications, giving your Lordship liberty to decide that application without being influenced by the order of the division bench, that itself gives an idea that, Lord, the division bench's order stands diluted. It's not that your Lordships will have to follow the division bench's order in toto. The Supreme Court clearly says that. If your Lordships read paragraph 3, this is nothing but, Lord, dilution of the order of the division bench. Otherwise, Lord, these expressions will have no meaning. It says without being influenced by the observations made in the impugned order passed by the division bench. 3, paragraph 3, second page. First is the liberty to file applications. And then, Lord, it says, if such proceedings are filed, the same be considered without being influenced by the observations made in the impugned order passed by the division. Lord, the suit, this order 40.
Gupta, I need your assistance to the extent that once a direction was passed in the appellate court, not any observation, it was a direction that you try the preliminary issue first, and that has not been interfered with the Honorable Supreme Court. Any development, Supreme Court has given you liberty to file that application and also given liberty to the trial judge to consider that application. But so far as the proceedings at the time when the SLP was filed, at that time 8 was also filed, 6 was also filed, and that was decided by the Honorable Division Bench that the preliminary issue is to be decided first.
Lord, 8 got dismissed. 8 was Order 7, Rule 11, which got dismissed. Then, Lord, they preferred an appeal. This is the order of the division bench passed in appeal. And, Lord, my reading of the otherwise, Lord, if your Lordships, Lord, have to go by the order of the division bench, the second part of the order will have no meaning at all. Because if your Lordship frames a preliminary issue and decides that first, then, Lord, the other part of the order becomes redundant. There has to be a harmonious reading of the order passed by the Supreme Court. Because the entire matter was before the Supreme Court. Lord, an occupier who's not paying, Lord, occupation charges, enjoying the property, was also before the Supreme Court. Supreme Court, Lord, obviously felt that this was beyond the scope of the SLP because it came out, arose out of an Order 7, Rule 11. So obviously, Lord, these liberties are given, considering the fact that, and that liberty has also been given by the division bench.
But if the preliminary issue is tried at an early date, your right to assert that application or move that application is not taken away.
But it is deferred.
But if the application of you, suppose for the sake of consideration, is allowed in your favor, suppose, and at the time of deciding the preliminary issue, it goes against you.
Lord, I'll answer this. Lord, this is the jurisdiction of the court is not being raised. This is that it's touching the jurisdiction of the court. It is not being raised for the first time after filing of the suit. The suit was entertained. The parties submitted to the jurisdiction, filed certain terms and conditions, based on which the court was invited to pass certain order.
Okay.
It is only when I filed the application seeking, Lord, occupation charges during the interregnum that this application has come under Order 7, Rule 11. Their case is that the eviction suit was filed on the basis of a notice of eviction, that notice is no longer a valid notice. During the pendency of the suit, that notice has become invalid in the sense that subsequent orders have been passed by the court. Now, my lord, I give an example. I file a suit for eviction under the Premises Tenancy Act. Now, my lord, the tenant has to comply in terms of Section 7. The court passes certain orders with regard to deposit of money and also consequential order that I can withdraw. The tenant defaults. Consequences are provided in the statute. This is not a suit under the Transfer of Property Act. Despite the order of court, the payment has not been made. I have come before the court. This is an application simpliciter for implementation of the order. Lord, I see no impediment in at least your lordship directing the money to be deposited in court. Even if your lordship feels that the money should not come to me, and before your lordship decides the question of jurisdiction, at least the money can be deposited in court.
Asha, this matter is appearing
I have
under
one
and
very small
heading to be
submission.
mentioned. Yes.
Milord, the Honorable Supreme Court, Milord, had given liberty, but the plaintiff, Milord, did not file any application. An application, Milord, is sine qua non because the order of 24th April 2024, Milord, requires modification for the submissions today being made on behalf of the plaintiff to go in record. And that liberty exactly was given by the Honorable Supreme Court in the second page, the first 5 lines of the order. So the plaintiff, Milord, has not filed any application. The plaintiff accepts the situation.
No, we can decide the application.
No,
of them.
but what has correctly fallen from your lordship is that if the preliminary issue, and it was a time-bound proceedings given by
Let
the
the
Honorable
6th of 2020 to come up for hearing. You have filed
your
your
lordship,
opposition.
Milord, I am objecting to this because the Honorable Supreme Court has not interfered with the division bench's order. The division bench's order had, Milord, stipulated 3 months' time. When the matter came up before Justice Mojumdar, Milord, was of the view that preliminary issue must be tested first. There is no application on board on behalf of the plaintiff asking for modification of Justice Mojumdar's order. Hence, Justice Mojumdar's order, Milord, stands. Submissions are being made, Milord, verbally before your lordship. And orders are being shown, Milord, without any affidavit. So, Milord, there is no ground before your lordship based on which Justice Mojumdar's order is going to be turned topsy-turvy. Today, if your lordship proceeds with GA6, then, Milord, it's going to be a reversal of the order passed by the previous determination. And there has to be, Milord, some reasons. The Supreme Court gave the liberty to file appropriate proceedings. There is no proceedings before your lordship. Because today, GA6 and GA8 both have been revived. The preliminary issue, Milord, will be framed by your lordship in
8 is
GA8.
revived.
Yes.
8 is revived by the order.
Yes, Milord, kindly see the division bench's order. Preliminary issue will be passed in continuation with GA8 because when your lordship is going to frame the preliminary issue, your lordship will peruse the petition and the affidavit which has been filed as opposition to GA8. That is exactly what the division bench has said.
Proceed this in accordance with having regard to developments taken place.
Milord, kindly see page 4. I had placed this.
Sorry.
Milord. We are of the view that the question raised in the application before the court below in GA8 should be tried as preliminary issue. And on the basis of the application,
This matter
the
is
affidavit is exchanged.
this
That
matter
what I
is appearing under the heading to be mentioned by order dated 24th April 2024 after passing of the order by the appellate court on 10th April 2024 following directions were issued. Since then,
But may I have my lord's kind leave?
yes. The order passed by the appellate court on 10th April 2024 was challenged before the Honorable Supreme Court in APOT 68 of 2024. Upon hearing, the following order was passed by the Honorable Court. Order quote for the It is found from the aforesaid order that the Honorable Supreme Court did not incline to interfere with the order, judgment and order passed by the High Court. Para, it is not in dispute. Liberty was granted to the parties to file appropriate proceedings. So it is informed that no such further application / proceedings has been filed. In view of the above, since it is found that the appellate court passed order for trying the preliminary suit at the first instance, it would be preferable and appropriate to try such issue pending the application being GA6 of 2022. এটা পর একটা করে framing of preliminary issues date বলুন। You have filed your written statement?
Yes, long back.
Learned Registrar original site is directed to comply order dated 24th April 2024 by furnishing a report as to the date of service of summons, date of appearance of the defendant as well as date of filing of the written statement, if any. Bolu date. Third March.
Milord, may I beseech your lordship, Milord, to also call for the records of GA8, because the Honorable Division Bench, Milord, has said that the application and their affidavit in opposition may be considered by your lordship for framing the preliminary issue. That's
Department
Department just for
directed to
assistance.
With regard to
Nothing
this submission, limited to this submission only, my lord, GA8 was never restored by the Honorable Division.
I never said it has been restored. I said it's revived.
Let me complete my submission. My lord, GA8 was never restored.
Here's the question raised in the applicant with the code below and GA8 should be tried as a preliminary. GA8. Department directed to place GA8 of 2023. Along with affidavit. You have filed your opposition?
Yes, it was below.
Along with the affidavits on the returnable date.
I'm most deeply obliged.
Your Lordship, I am appearing for the plaintiff in this matter, my Lord. Your Lordship, I can see that I have been disabled from starting my video.
I couldn't appear last day. So I was appearing online but could not enter this.
They filed an application.
They have produced from the plaintiff that he doesn't want to proceed with the suit.
Yes, Your Lordship, the instruction is to withdraw the suit proceeding, my Lord. We had handed over a letter dated 20th-25.
Basically, Your Lordship, this is a
suit for declaration and partition of a family property, Your Lordship. I am told, Your Lordship, I don't know what transpired with the plaintiffs, Your Lordship. The terms of settlement has been finalized. It was sent to the plaintiff for signatures. Anyhow, I am not into that now. Since the plaintiff wants to withdraw the suit, Your Lordship would kindly give me liberty to get my clients transposed into the stand of a plaintiff, since it is a declaratory suit and a partition suit between the family members, Your Lordship. I was seeking time, Your Lordship. My clients want to transpose themselves into the stand of the plaintiff and let the plaintiff speak.
So, learned advocate for the plaintiff.
Lordship,
This is the difficulty where the parties are at loggerheads. One is applying for transposition, the other. You are a receiver. Now you are stuck between the parties.
Lordship, we will take care of the receiver. We will apply for his discharge and for appointment of fresh receiver. We will do it.
To continue, madam. I filed up to date account.
You file an application for transposition.
We will.
If they want to withdraw, fine. And on that date, we will take.
We will apply for his retirement and for appointment of fresh receiver. Only one thing, Your Lordship, since the receiver is here, there is only one, Your Lordship. There are two orders passed by this the suit court, Your Lordship. The receiver was under the possession of the suit property, Your Lordship. He was to be directed to make inventory and to receive rents from them. Your Lordship, I was only provided comments to Your Lordship that the inventory list may kindly be provided to the parties, Your Lordship. And
there was a direction to provide.
Your Lordship.
If I can find it out, because I was the receiver since 1989, my lord. At that point of time, the clerk who used to look after all this paperwork, he died, my lord, before completion. If I get the inventory list, I will certainly provide it. There is no issue on that.
Lordship, the problem is, Your Lordship,
and the parties are landed in the same premises, my lord. They are aware of everything.
There are 25 parties, Your Lordship. There are 25 shareholders in the property all over world, Your Lordship. So my learned friend is not aware. Now, Lordship, the only problem is, Your Lordship, the learned receiver has filed a report. We are not disputing the report. He has not described from whom he is collecting the rents.
Yes,
who is paying rents to them? To him. The parties are at loggerhead. Okay, then we could have heard. But today, the parties who will be coming in will be sharing the suit property, Your Lordship, who will be receiving the rents, from whom they will receive the rent. And if who are paying rent to my learned friend and he is collecting rents.
This matter is appearing under the heading to be mentioned.
Let him provide the details, Your Lordship.
Purnima Lala Sengupta, learned advocate for the plaintiff, submits that the plaintiff number 1A, who is also the constituted attorney of the other plaintiffs, does not intend to proceed with the suit. Mr. Deepak Jain, learned advocate appearing for defendant number 2B, 2C and 2D, submits that his client shall take appropriate steps for transposition in this suit as plaintiffs. He also submits that the learned receiver be directed to hand over a copy of the inventory made by him. Mr. Devanand Misra, learned advocate receiver, submits that he is a receiver since 1989 and has to search the records to get a copy of the inventory. This was submitted before the court?
Yes, my lord. It must be submitted.
You can get the certified copy of that.
Not there in the records, Your Lordship.
No,
That is why I am making this.
That is why, my lord,
Even the parties don't have that.
If the court records are not there, my lord, how my learned friend is expecting 35 years, 36 years old
That is why.
to give it to him. To so long
Lordship,
till
but
today, they are
He is
coming
an
for
officer
it.
of a court, Your Lordship. He should be knowing from whom he is collecting rents.
I've said, my lord.
After 2 weeks. In the meantime, you take out this application?
We will. Lordship would kindly give me 4 weeks because my clients are not
Please
in
this
India.
matter after 4 weeks.
As Your Lordship says.
Grateful, Your Lordship.
Heading to be mentioned. To be
At
mentioned.
least the receiver be directed from whom he is collecting rents. That would suffice so that we may know what is
He
the correct
says
position.
that he will search the copy of the inventory. If it is found, he will hand it over.
Inventory is Lordship, that is one thing. But as per the report, he is collecting rent for 5
I
months.
have not
for
collected the rent from last August 2024.
the last rent he has received. Let the list be
Yes,
given to
that
us.
list I
That
can
we will
provide,
do.
but
That is
current
what I am
record-
asking.
Yes,
Okay, ওটা তাহলে কেটে দিন, ওই inventory ওটা কেটে দিন. He submits that a list of
last account matter.
last account you will.
Yes.
Last account he has not disclosed. Your Lordship, with
No, no, I
greatest of
filed this
respect,
matter
he has filed the accounts, but he has not disclosed
will-
from whom he has received.
Learned
Wait a minute,
receiver, advocate receiver undertakes to furnish a list of the tenants from whom he has collected rent till August 2024.
Oblige, your Lordships.
Not today. The papers not received, sir. Tomorrow? 26. Okay, 25 not today, 26.
Lord, this matter, my lord, granted discovery is proceeding for the partition of these properties. And my lord,
Why this is under to be mentioned?
My lord, I am the commissioner of partition with regard to a big property where there are 5 shareholders. My lord, pursuant to an agreement which was entered into by and between the predecessor and interest of all these 5 present groups, my lord, certain portions were to be divided amongst them. That division has been made and those portions have already been allotted during my presence. My lord, thereafter, there are also certain portions left which are occupied by third persons and which are also vacant. My lord, now these portions are to be valued and there are to be 5 equal portions which have to be divided. For this purpose, my lord, a surveyor was appointed previously, my lord, who had made calculations with regard to the total floor area and what was occupied by whom, and pursuant to which the allocation as per the agreement was made. The rest of the portion, my lord, which remains was to be valued. My lord, in the meantime, the valuer has passed away just in January this year. So, my lord, that we just got to know. So I was only humbly praying, my lord, that may your lordship, from your lordship's panel of surveyors, appoint someone, my lord, so that there is no dispute between the parties, my lord. Or, my lord, may 2-3 options be given from which, my lord, the parties can select one and the rest of the job can be continued and finished with. And, my lord, and one more submission. And, my lord, one more submission, my lord.
Who was the valuer?
Mr. Sen, Mr. Prashanto Sen.
He has expired.
He has expired this January.
Okay.
And, my lord, may the incumbent, my lord, consider the previous reports also. There have been 2 or 3 reports.
Valuer will consider the valuation report of
Yes,
the
previous reports already on record. These are the 2 submissions.
One more prayer.
This matter is appearing under
for
the
Mr. Ghosh, there should be a remuneration, further remuneration. Long back, he has received remuneration, so one remuneration should be there.
that is appearing under the heading to be mentioned. It is informed by Mr. Swarnendu Ghosh, Learned Advocate Commissioner, that the previous valuer, Mr. Prashanto Sen, has expired in the month of January 2025. For such reason, a new valuer is to be appointed from the panel prepared by this court. In view of such submissions, let Mr. So-and-so be appointed as a valuer to cause valuation of the property in question. The valuer shall also take into consideration the previous valuation made by the previous valuer. Learned Advocate Commissioner is entitled to receive further remuneration of rupees 50,000, which shall be borne by the parties equally.
My lord, only one prayer. My lord, your lordship has been pleased to remain blank with regard to one name. In case of his failure, my lord, may another option be given.
Lordship kindly gives 2-3 options at least.
তাহলে একটা কাজ করি, ওটা direction দিয়ে register original site is directed to
that's
appoint a valuer
as your lordship pleases
to do the needful.
I'm deeply obliged.
নামটা ওখানে ক্যাপ থেকে
Lordship kindly makes
কেটে
it
দিন।
returnable after 2 weeks or so, so that.
List this matter in the Asha, list this matter, go out of list with liberty to mention. Complete that and come back. Chalo.
Your Lordship, may I complete the Lordship, item number 32, Your Lordship.
32?
Yes, Lordship. I am for the plaintiff, my lord. Lordship,
Not now.
32, my senior, Mr. Amaswadi is hospitalized. So, Your Lordship.
Okay, when the matter will be taken up, you remain present, it will be adjourned.
We
Okay,
are praying for adjournment, my lord. So,
32 not required. When it will be called, he will respond.
I'm grateful.